quickly list item number 1.
May mention bail in appeal, my lord. I pray for bail, my lord, in the appeal against conviction, my lord.
Which matter?
No, out of list, my lord.
Oh, it's a division bench matter.
Yes, yes.
Which year that is?
2023, my lord.
2023. That is not assigned to us, I think.
2010 point.
Just a minute, let us see.
Sorry, my lord.
It's not assigned
To 2010. I'm mentioning on the sorry.
Yes.
May I please alert? Millets, I am on DC Millet.
Yeah.
Millet, I have filed this writ petition criminal because the son of the petitioner has gone missing since 19/7/2023. No satisfactory response nor any kind of action has been taken by the local PS. That's why this writ petition criminal has been filed.
Your son is now staying with his wife.
No, kindly see the
You
paragraph number 4.
have stated that opposite party number 5
Yes.
claims the son of the petitioner as her husband, and that she is a married person, being the mother of 2 kids. So your son is now staying in the company of his wife, having 2 children. What is the question of habeas corpus?
Kindly listen. The OP number 5 illegally detained the son of the present petitioner. Due to my personal effort and source, I came to know that he is staying with that OP number 5. I have approached several times before
You want to disturb the marital life of your son.
No, he is married.
Your son is now major. He has already married, as it appears. He has already married and having 2 children. And
No.
your daughter-in-law is opposite party number 5. Why are you disturbing their marital lives?
Milord, he is a boy of 22 years and he has never had that kids. He has gone missing from July 19, 2023, Milord.
Staying with his wife in the in-laws' house, perhaps.
Kindly instruction be made.
No, instruction. Unnecessarily, you are just to see that a notice is issued from this court and some kind of, it will disturb their marital life.
Milord, I can find an affidavit that he has no kids. This is my instruction.
Your claim itself is very clear, sir.
Your government itself indicates that if the son would have been detained, he is the best person to come out, and he is now silently staying, and he is staying with his wife and children, and you, the father-in-law of the opposite party number 5, trying to disturb the marital life. If you have any other grievance, fight it out in a separate forum. What is the question of illegal detention of your son?
There is no such marriage has already been occurred. There is no such marriage.
Forum there, you fight it in the proper forum.
And he is a major man.
It's all right.
He has his own concept.
Even if the petitioner's son has no kids, he has not get married.
All right. After going through the averments taken in the WPCR, and since the son of the opposite party, son of the petitioner, is admittedly major, and it appears that he's staying in the company of his wife, bracket opposite party number 5, and we don't find anything that he has been illegally detained or wrongfully confined, and therefore this habeas corpus writ petition is not maintainable. Accordingly, stands dismissed. Yes.
Next.
Item number 2.
May please, Your Lordship. In this case, Your Lordship, the minor daughter of the present petitioner, 13 years and 8 months, while she was
What is the spelling of habeas corpus? Come to your prayer portion.
typical
Have you
error.
correctly reflected it?
Is a typical error.
Typographical error. So what should be, if it is corrected?
E,
Tell the spelling of habeas corpus.
E is faster.
Huh?
E,
No, first tell me habeas. What is the spelling?
B, A,
Start from the H.
yes.
Huh?
H, B, H, B, A, H.
H, A, tapre? Are you aware? Hey, tam kagaz dele. Give him a urgent slip. Write down habeas corpus. What you have written?
A, H first.
नहीं अपन लिखिले HABEOUS and CORPOUS. This is this correct spelling.
EUS.
It will be taken off tomorrow. Get it corrected. First know what is the spelling of habeas corpus. Next.
Item number 3.
Yes.
Item number 4.
For production of minor daughter of the petitioner, my lord, is missing since 13/9/2023, my lord. The date of birth is the real is my lord, 16 years, my lord.
You have lost the FIR.
My lord.
Your FIR has been registered.
My lord.
Where is the formal FIR copy?
Page 8, my lord.
Okay. You have named the person.
Yes, my lord.
And what is the age of your daughter?
16 years, my lord. 25/9/2007, my lord.
So 16 years he has completed.
My lord.
Now running 17.
My lord.
Since when, according to you, she has eloped with this boy?
My lord.
What is the date? 3/9/23. 13. हाँ 2023 रे लिखुଛି ରାତି 12ଟା ବେଳେ ଶୋଇଥିଲା ବେଳେ ହଁ 13 ବୋଧେ ଆଚ୍ଛା ସେଟା 0 ତ 13/9/2000 ହଁ 14/9 ରେ ଖୋଜିଲୁ ପାଇଲୁନି ଶିବପ୍ରସାଦ ଜେନା. So Mr. Tripathi, what is your instruction, or it is coming for the first time? You take instruction and produce the case record to show that what progress you have made. It is lodged on the FIR is dated 17/9/23. So more than 1.5 months have already passed. This writ petition has been filed by the mother of the victim with a prayer to in the nature of habeas corpus for production of his minor daughter, who alleged to have been kidnapped by the opposite party number 4, Shiva Prasad Jena. And counsel for the petitioner placed the copy of the HSC certificate, which is annexed to the writ petition as Annexure 1, to indicate that the victim girl is now minor. And since 13/9/2023, she has fled away. and the petitioner is suspecting that the opposite party number 4 is responsible for the kidnapping of our minor daughter. It appears that in connection with the kidnapping, the petitioner has lodged the first information report before the inspector in charge of Dhamnagar police station on 17/9/2023, and Dhamnagar PS case number 440 dated 17/9/2023 has been registered under section 363 of the Indian Penal Code against the opposite party number 4. Let the Learning Council for the state obtain instruction about the status of the case and whether the steps taken by the investigating officer to rescue the victim and produce the case diary on the next date. The investigating officer shall remain present the next date, which is fixed to Gote Saptah time doju.
Right.
It will come on 20th of November 2023. All right. Yeah.
Free copy of it.
Free copy of the order.
Item number 5.
The petition is a defense personnel now working under border security force posted at my lord Jammu. During his long stay without granting any leave at Jammu and Kashmir, my lord, the misfortune came to his life. His wife has invited second marriage and manipulated some documents in the birth register of his daughter and also admission register in Kendriya Vidyalaya. However,
there has been divorce between you and your wife.
No, my lord, divorce. When I was at Jammu and Kashmir, ex parte decree she has taken ex parte decree against that order.
It's all right. You have challenged the
matrimonial appeal is pending.
Matrimonial appeal.
So, my lord, presently I am before your lordship to rescue my minor daughter because where she is and because
with her mother, why are you worried? Or if according to your averments, she has already married to somebody else. So she is living a peaceful marriage life. So why are you trying to disturb the marital life of your daughter?
No, my daughter is not married. My daughter, wife.
Your wife has already married for the second time. And what about your daughter? Some averment has been taken?
I am not known by because the.
It's all right. If
at least, my lord, the whereabouts of my daughter.
When you have already approached a forum before this court, if you want any interim relief, you should have immediately prayed for that. That some kind of restraint order should be passed so that she will not remarry till the adjudication of the matrimonial appeal. Because there is a fixed period. If during that period it is not, he can remarry.
Because it is the my lord the procedure under the my lord the Family Court Act and guardianship
and divorce is allowed in favor of either the husband or the wife if the other side do not challenge it within a particular period or do not bring any kind of so whether that prohibits the marrying again, that is very clear in that. It was your duty the moment you came to know, when you have already approached and you have not filed any interim application to that effect and your wife has already got married for the second time. Whatever it will happen, that will be the subject to the result of that matrimonial appeal.
My lord, I am not concerned about.
Now, what is the age of your daughter?
My lord, 11 years.
So she is staying with her mother.
My lord, that is why, my lord, actually, in fact, I was praying the child welfare committee. Child welfare committee. So It is admitted. I have approached
Para
the Child
50.
Welfare Committee.
Para 50, just a minute. Yeah.
That the petition of indulgence of the Child Welfare Committee constituted under District Juvenile Court, Puri, has also approached in filing proper application on 2/3/2022, but it was not properly attended to. He has also approached this honorable court by in WBC note so and so for appropriate direction to the Child Welfare Committee, Puri, to take care of the minor child and also to remain under safe custody in view of the provisions as so and so. And the honorable court by order dated Etiki called for the report, my lord. That
No. You have already taken all these steps against the ex parte divorce, if it is at all. You have already approached this court in Mata. Against, you have filed a petition before the Child Welfare Committee, and then due to their delay in disposal of your application, you have already approached, and both the matters are sub judice before this court. So again, you have filed another application.
When my minor daughter, through my lord, reliable person of my family, intimated to you tell my father to rescue me because I have been tortured by the.
No, it's all right, but how many forums you will haunt at a time?
Well, because Child Welfare Committee, they have taken.
No, you have come in
So
the read
my
petition, sir.
my lord,
Petitions are
they
pending
rescued
on
the minor.
committee.
They rescued the minor daughter and again handed over the newly married husband.
That means whereabouts is well known.
So, no,
A statutory body has already intervened in the
my
matter.
lord, intervention in the sense, my lord,
Hmm.
only took up the rescued the minor girl,
Yes.
again handed over,
Why?
handed over to the
So
newly
seeing
married
the
husband.
welfare of the child, they
Because
have
she,
filed.
because newly husband, my lord, but in
Now-
fact,
Now the forum is otherwise. If you want to engage yourself or take him, then the other forum are available. We are not here to advise you that what forum, in which forum, what proceeding you are to file to claim the guardianship. Suppose your daughter is now staying with the mother. We cannot say that a daughter staying with the mother is
Is illegal
the
confinement.
illegal confinement.
let her
So
stay.
that
let her
ends
stay.
this proceeding.
No, my- let her stay with her mother.
So then
Because no, my lord.
the matter over.
No,
The
my lord,
scope
see
of this
that-
proceeding, the scope of this habeas corpus proceeding is only to the extent that whether your daughter has been illegally confined or wrongfully detained by anybody or not. If your daughter is staying in the company of the mother and you have no objection, matter ends there.
No, my lord. Very often, my minor daughter, intimated to me, departing my.
Sir,
departing
let us not go for a roving inquiry. What will happen? What kind of apprehension you are having? We are not.
My lord, the local police, the annexure 13, page 40. So they are well to some extent because after expiry of my leave, I am at Tripura. So the local police is saying that we are searching your minor daughter. In many times she is not with her mother. So that is why ma पाखे बेले रहुनी
Claim guardianship in a other forum. There will be evidence that the daughter's opinion will be taken and best interest
Right.
will be taken into account by the concerned court. That is settled law. What is that?
Guardianship will be disputed because the revised birth certificate is issued in my favor. When it was issued by
ଆରେ
to a
ସେଇଟା
stranger.
ମା ପାଖରେ ରହିବ, ମା ଯେତେବେଳେ ଆଉ ଗୋଟେ ବିବାହ କରିସାରିଲାଣି କି ଝିଅ ବାପା ପାଖରେ ରହିବ ଏଇ ପରିସ୍ଥିତିରେ, ସେଇଟା କୋର୍ଟ ଡିସାଇଡ କରିବ, ଏଭିଡେନ୍ସ ନବ, ତାକୁ ଝିଅକୁ ପଚାରିବ, ତାର ମତାମତ ନବ, ସେ ତା ପାଇଁ ବୋଥ ସାଇଡ ର ଏଭିଡେନ୍ସ ଦେଖିକିନି ultimately court. That's a separate forum altogether. How we will decide it in a habeas corpus writ petition? That is the limited point we are asking you, that how we'll decide it here.
My prayer, at least the police may
Sorry,
give some report.
Had the Learned Counsel for the petitioner and counsel for the state. It appears that,
where she is going, I am on your about the
this
facts.
writ petition has been filed by the petitioner Lakshmi Narayan Mahanti with a prayer in the nature of habeas corpus, with a prayer to rescue his minor daughter from the illegal detention of the stranger's house. where his life and liberty in every moment is under threat, despair. After going through the averments, we find that there has already been uh, divorce between the petitioner and his wife before in the appropriate court, and the matter is under challenge before this court in MATA number kete kundu?
129 by
MATA number 129 of
2022.
22, and another proceeding is also sub judice before this court in what is the number to the paragraph?
WPC 7853 by
WPC number 7853 of 2023.
22.
22, in which direction has been sought for to the Child Welfare Committee, Puri, to take care of the minor child. Stop. It is stated by the Land Council for the petitioner that both the cases are sub judice before this court. It is also brought to our notice that after the divorce decree, the wife of the petitioner has already married to another person. Since the dispute, the minor daughter of the petitioner is now staying in the company of her mother, and under no stretch of imagination, it can be said that she has been illegally detained or wrongfully confined by her mother. If the petitioner wants claim guardianship, the other forums are available, and in view of the state of affairs, we are not inclined to entertain this habeas corpus writ petition, which is accordingly dismissed. Yes.
Matter number 6.
My lord, the minor daughter has been kidnapped by OP number 5 on dated 3/10/2023. The FIR has been,
You have lost the FIR
my lord,
on 5/10/2023.
my lord,
So you have named also the accused persons.
my lord,
And that man is opposite party number 5.
my lord.
What is the age of your daughter?
Daughter is 16 years. Annexed to my lord.
39 2007 means he has completed 16 years.
My lord.
Okay, 17 years. So, Mr. Das,
I'll take instance.
okay. This writ petition in the nature of habeas corpus has been filed by the petitioner with a prayer for no, your prayer is in a different nature. It is to be filed.
My
It
lord,
is to be.
local police, I have visited again and again to the local.
No, it is to
Like
be before a single bench. If you want investigation,
Right.
there is. It is not a habeas corpus writ
No, no.
petition
My,
You want the investigation to be taken
by the crime branch, so that will be dealt to by
No.
the single bench.
my
There
lord,
is no prayer to cause production of your victim girl or to rescue the victim girl. There is no such
I have
prayer.
stated in my
No,
movement, my lord.
Your prayer is, if we are correct, why the FIR under Annexure 1 in Basudevpur PS case number so and so shall not be caused for investigation by the crime branch other than the local. This is completely the jurisdiction of the single bench.
So you are not satisfied with the investigation.
I am.
So, yeah, that is the cause.
The
No.
minor girl has not been
No,
taken.
anyway.
All right, in view of the nature of prayer, may place this matter before the. This is not a writ of habeas. We are of the view that this is not a writ petition in the nature of habeas corpus. Rather, a prayer has been made for investigation of Basudevpur PS case number 664 of 2023 by Crime Branch. Put up this matter before the appropriate bench. Yes, next.
Number 7.
Item number 3.
3.
Item number 3. Yes.
Petitioner is the mother of the victim girl, my lord.
Yeah.
Age of the girl is, my lord, 13 years, my lord.
Mm.
She has been illegally detained by the opposite party number 2.
Who is opposite party number 2?
Child welfare committee.
Child welfare committee.
My lord. My lord.
The statutory body has illegally confined.
My lord.
Statutory body has kept your daughter, must be in a safe.
My lord, they have suddenly reached to the house of the present petitioner, my lord.
Why?
My lord,
there is any previous cases or what?
No, nothing, my lord. There is a dispute between the brother-in-law of the petitioner, civil dispute, my lord. Thereafter, and the
how can be it? The statutory authority, they are performing their duty. There must be some reason for taking your daughter. What is that reason they have assigned when they took your daughter from your custody?
On the basis of the complaint of the villagers.
Yeah.
That my daughter.
What they complained?
They complained that she is talking with a boy, and that's why they illegally detained the boy and the girl without the consent of the parents, my lord. And for one day and night they have detained. Thereafter they handed.
Tripathi, this is now in this collector's. Just take instruction. Why? What is the real correct state of affairs? We can take up day after tomorrow. Just ascertain. We are not passing any order.
ସେ ଝିଅ ଲର୍ଡସିପ ହାତ କାଟି ଟେଲିଫୋନରେ ଫଟୋ ପଠେଇଥିଲା ମା ପାଖକୁ ଯେ if will not rescue that she will.
Now whether we will bring it in the supplementary list. Okay.
A list continue for some. I will take it.
It will be taken up from the weekly list on day after tomorrow.
Number 7.
On the last day, item 7, I am my lord. We have state has gone filed SLP, my lord, the Supreme Court.
No.
So I need some time to get the number and to
against the order passed in the writ appeal.
My lord, writ appeal was disposed of on 6/9/2022.
Anyway, this is the instruction that he has taken. The SLP has already been filed before the court. We'll allow him to take instruction.
What period you want?
Minimum, my lord, 1 month.
You have already filed?
Yes, already filed.
This contempt proceeding, it a first time Ashina contempt proceeding. All right, then you take down the the Learned Counsel for the state submitted that against the what is the writ appeal number?
96 of
2016 against the order passed in WPC number 21856 of 2020. Order against the judgment and order dated 24/6/2014 passed in WPC number 21856 of 2010, which was confirmed in writ appeal number 96 of 2016 disposed of on
6/9/2022.
6/9/2022, the state of Orissa has approached the Honorable Supreme Court of India, and the matter may be taken up after 4 weeks to obtain instruction about the status of the SLP. So, Mr. We'll take up this matter on 4th December. raised this matter on 4th December 2023. The Learning Council for the state shall apprise this court about the uh, status of the SLP on the next date. Free copy of the order be handed over to the Learning Council. Yes.
Item number 8.
The victim girl rescue, that is
Yeah.
good.
Anand, paper kahu rakhna adi. Paper to copy diye. Who paragraph election di?
My lord, para 23, your lordship.
20?
23, my last week.
He is now staying with her husband.
Uncle.
No, married to one
Sanatan
Sushant Kumar Behera.
Married.
Bartaman the uncle house re. All right,
She was handed over to her parents, 26 para. She has been handed over to her parents.
but
Para
you
26.
said that he stayed in the uncle's house, really?
During when he was missing, my lord, that time.
Now she is in the company of her parents, right? All right. This IIC is present?
Yes, your lord.
Please come. You are Mr. N.R. Mahanti.
Yes, sir.
Mr. N.R. Mahanti, IIC of Ranpur Police Station is present, and he submitted written instruction in which it is mentioned that the victim has already been rescued and is found to have been married to one Sushant Kumar Behera. And on 27/10/2023, the victim has been handed over to her parents after completion of all formalities. Since the victim has been rescued, this petition is disposed of. Personal appearance of IIC is dispensed with. Yes.
Item number 9.
May I please? Your Lord, the prayer in the read petition, and have a glance to page 19 of the read petition. For taking suitable action against the opposite party notified to he and proceed against them for illegally detention in custody of the petitioner. Pursuant to the earlier decision of this court, under Annexure 4, page 44, my lord. Running page 47, can you have a glance?
What happened?
Running page 47, your lordship, have a glance. Earlier, I approached this honorable court in the read petition that the honorable High Court been pleased to page 47 have a glance. Case
47.
My lord, the case involving here a cause of action to be involved in a criminal proceeding, and the case is also involving detention appears to be illegal detention. By virtue of this order,
47, it is case involved involved criminal. Legal in the report civil it is not mental so liberty. Okay.
That was his
Yes.
contention before
the genesis of the case, your lordship, have a glance, Annexure 1. Page 21. There is a 110 proceeding
Yes.
initiated by virtue of a non-FR dated 7/3/22. Your lordship, have a glance, page 21. And by virtue of that non-affair, 110 proceedings were initiated. And the IIC sought for remand on 13/3/2023, stating therein that there is 6 cases involved against the petitioner. That is as it appears from page 21. And by virtue of that 110 proceeding, the IIC has taken remand to the petitioner and forwarded to the custody. And in the case which has been disclosed in 110 proceeding, that is a case dated 11/3/2023, where the petitioner was arrested, and on the same day, the learned magistrate was released him on bail. Since that is a Saturday, on the very next day, on 13/3, this 110 proceeding was initiated. And consequent upon the production, he has also remanded to the custody in this connection with this 110 case. On the very next day, on 14/3, I have been asked to file bond of 10,000 with good behavior. That has already been produced on the same day, on 14/3. On the said date, the learned magistrate, on the guise of inquiry, forwarded to the petitioner to the custody and adjourned the case to 25/3/2023. And from 16/3
No, 110 proceeding, you come to the order dated 14/3/2022.
Yes, sir.
It reveals that the delinquent Deepa alias Swanso is produced today. He is the petitioner.
Yes, my lord.
Yes. Okay. My petitioner,
Wife, husband of the petitioner.
Swanso is produced from the today from jail custody in the PR. Is read over and explained to Swanso. Delinquent denied the allegation. As per the FIR, the delinquent is so desperate and dangerous that to render his being large without security is hazardous to the community, and so he's called upon to show cause as to why he shall not execute the bonds one. Okay, delinquent neither prays for release on good behavior one nor executes one, and delinquent is detained in custody. So then what happened?
I challenge this proceeding before the London district judge, where it has been held that the entire proceeding is illegal, and detention is where it has been held that the entire proceeding is illegal.
Where is that order?
That is order Annexure 4.
Annexure 4 is the order of this court. You said the district judge you approved.
That
Page
is in
38.
page 43, the relevant part of that order.
Page 38.
40. So,
So
in view of the aforesaid discussion, this court is of the view that the magistrate was gone wrong in imposing further condition on the petitioner while accepting the bonds furnished by him for keeping of good behavior, and since the said order being illegal and without jurisdiction, them is liable to be set aside. According to the order dated so and so, to the extent of imposing condition against the petitioner while accepting the bonds is hereby set aside, and the revision is allowed. So
I may be permitted to place
set aside.
I may be permitted to place
that order which you are set aside is not this order which you are showing. This is the order dated, just a minute. This is the order dated 14/3/2022. That means that some subsequent order was passed. That is on 27/4/2022, which you had challenged before the district judge. That order you are not producing before this court. And then after the district judge passed the order, what happened?
It is thereafter on the very next day, the petitioner was released on bail by the magistrate.
Yes.
So far as detention of the petitioner from 16/3/22 till 25/3/22, his detention in the custody is illegal.
How it is illegal?
Because, my lord,
the court has remanded him to custody.
Yes, my lord, in the guise of inquiry.
Whatever it may be, that order is set aside. That's a different matter. But how can it be?
Order was set aside imposing some conditions. On release of the petitioner on bail, the magistrate imposed certain conditions for his appearance.
If the order of the magistrate is wrong, you are to approach the higher court, and the higher court is set aside, then you get the relief. What is the question of?
No, my lord, your lordship, I have glanced page 24, order dated 16/3/22.
Yes. What is
16.3.
now? What is your further prayer now in this?
Now, my lord, in a decision of our Honorable Apex Court, it has been held that magistrate has no authority in a 110 proceeding. In the guise of inquiry, he can detain the delinquent in custody. Here is the case what happened from the entire order sheet from 16.3.22. There, the magistrate has forwarded, despite the fact that I have produced the surety bond to the custody in the guise of inquiry.
No, the order, you see, this order, particular order which has been passed on 14/3/2022, has it been set aside by any court?
No, my lord.
Then
My lord, the subsequent order 16.3, your lordship,
that is not, you are not bringing that on record. You are only bringing on record a order dated 14/3/2022, and you are not producing any order or any subsequent order to that effect. But how then, if you are not producing, how can we say that the order has been passed in an illegal manner? This order is plain and simple. The magistrate asked you to show cause as to why you shall not execute a bond of rupees 10,000 in two local sureties.
Yes, my lord.
So if you say that I want to file show cause, you should have sought for time.
I have filed show cause on very same day. The next page, your lordship.
And interestingly, my lord,
page 24. Page 24, your lordship. On the very same day, when I have been asked to produce the bond on 14/3, on the very same day and later I have produced the bond.
What
Page
order
23.
was passed further?
Yes, my lord.
that is page 23.
Non-counsel for the delinquent appeared with Binama and filed petition with a prayer to release the delinquent on strength of PR bond. However, show cause not filed. Non-counsel for the state is present. Peruse the case record as it appears from 14/3. This court have already granted liberty to the delinquent to furnish good behavior bond of 10,000 each with two local solvent surety for his release. Instead of filing the same, the delinquent prayed for release the strength of a good behavior bond. As PR bond submitted by IC Cantonment PS, it is revealed that the delinquent was involved in 6 cases in Madhupatna PS case. The delinquent is a habitual criminal and for his notorious activities and always create law and order situation and for which the tranquility disrupted in the locality. The delinquent is also desperate, dangerous, never hesitate to do any overact during committing crime and also hazardous to the society as well as peace, having people of the locality. Besides, the non-FIR number 14/22 categorically reveals that the delinquents also desperate, dangerous, never hesitate to any other overact during committing crime, as well as peace-loving people of the locality. In view of the above, the status report will call for from the IIC, Madhupatna PS regarding insolvent of the delinquent in the cases mentioned in PR before 25/3/23. After receipt of the said case, necessary order will be passed. Put to bond restrict. So it is thereafter, Miller, the delinquent was sent to custody. On the very 16/3, your lordship have glanced the very next page 24. I have produced peace behavior bond affidavit along with sureties on 16/3 by way of advance petition. By verifying the same, the learned magistrate again put up the matter on 25 for production of the delinquent and awaiting report. And on 25, page 25, your lordship have a glance, order dated 25. On the said date, I have been released on bail.
You see, 110 proceeding is a totally different proceeding.
Yes.
Suppose you have been released on bail even on those cases, but if you are an habitual offender, this proceeding is meant for that.
Yes.
The proceeding is meant that security is taken for the good behavior, because the person is continuously one after another is indulging himself in different type of criminal cases, and his presence in the society is hazardous. That was the report furnished by the concerned IIC to the executive magistrate, and also all those case details were furnished. Magistrate became satisfied. Then he asked you to file show cause as to why you will not execute a bond to keep good, to have good behavior.
That is what my submission, page 26, your lordship have glanced, so far as 6 cases is concerned, has been appeared from the order dated 14/3. The details of 6 cases has been mentioned.
Yes.
Page 28.
Yes.
Out of these cases, my lord, I have filed by way of count a rejoinder affidavit. Out of these cases, from previous case number 150/18, petitioner is no way involved in that case. He is not there.
We are not here to analyze those whether what material is there, whether it is sufficient or not to file charge sheet or
On
not.
the basis of this, 110 proceeding was
It's all right.
initiated. This was the prior case.
In each case, what is the accusation against you? Whether you are
I am not the accused in that case.
properly taken into custody, whether you have been granted bail.
IIC has intentionally this has been submitted. For a moment.
Now, why have you filed this writ petition?
So far as number 6, serial number 6
question is that where is the illegal detention? A judicial authority, the executive magistrate, he has passed the order on the basis of the petition filed by, and the judicial order, ultimately one order has been set aside.
I have only one grievance.
Yes.
My grievance is, so far as the Honorable Appeal Court has held, in a guise of an inquiry under section 110, the magistrate has no power to.
What is the fact? You are jumping to the conclusion of the case.
That is not there, Miller. That is what the Honorable Appeal Court has held. Here in the case, Miller, in the guise of inquiry, I have been sent to custody from 16 to 25. Miller, so far as the cases are as you mentioned, Miller, out of these cases, Miller, the non-FIR was dated 7/3. And the case mentioned at page 28 is dated 11/3. How can the IIC know that on 7/3, 6 cases was against me, Miller? That is what that entire document has filed by of rejoinder. Paragraph page 28 disclose that 6 cases against me, out of which first cases I am not the accused. And the last case of previous case number 58, that was instituted on 11/3. And the non-FIR was dated 7/3, much prior to 11/3, Miller.
Are the learned counsel for the petitioner, learned counsel for the state? This writ petition has been filed.
May I please, Miller, a decision your lordship may report?
It's a prayer, file the decision with a prayer for passing appropriate order. In the light of the order of this court dated 26/9/2022 in WC number 22336 of 2022 as per annexure 4. It appears that when the petitioner approached this court in the aforesaid writ petition, this court, a single judge of this court found that the case involves cause of action to be involved in a criminal proceeding, and where there is accusation of illegal detention. Accordingly, dismiss the writ petition as withdrawn. Our liberty was granted to the petitioner to file litigation under appropriate nomenclature. Therefore, the prayer made that in the writ petition in this WPCRL, that to pass order in the light of the order is totally misconceived. It appears that the petitioner has been detained in custody as per the order passed by the executive magistrate in a proceeding under section 110 of CRPC, which was instituted after receiving the prosecution report from the IIC Madhupatana police station. And it appears that the petitioner is a habitual offender. Petitioner son na? No. Petitioner himself. Acha. Eta ki? Ha. Jivan ha. Petitioner's husband, is an habitual offender, and he is involved in as many as 6 cases of Madhupatana police station. The learned counsel for the petitioner submitted that some of the cases have been illegally instituted against the petitioner, and the petitioner has been released on bail, and therefore there was no justification for the inspector in charge of Madhupatana police station to submit a prosecution report before the additional DCP cum executive magistrate Cuttack UPD. The Land Council further brought to the notice of this court that when a revision petition was filed before the London Session Judge Cuttack by its criminal revision number 100 of 2022, challenging the order dated 27/4/2022 passed by the ADCP cum executive magistrate, under which the London executive magistrate refused to waive the personal appearance of the delinquent before the IAC Madhupatana police station. The revisional has been pleased to set aside the order dated 27/4/2022 to the extent of imposing condition against the petitioner while accepting the bonds, and the revision was allowed. After going through the writ petition, averments taken in the writ petition, we find that the prayer made in this writ petition is totally misconceived, and this court is not inclined to entertain this writ petition, which is accordingly dismissed. Yes, next.
May I submit your lordship to record my submission with regard to the fact.
Yes, next, please.
Item number 10.
May I please your lordship? Lordship, I am the unfortunate mother petitioner.
Yeah.
Lordship, already the age has crossed. Since the detainee, the victim has more than 18 years right now. So I am having only one prayer, Lordship. Police may kindly be instructed to get the
several orders, Mr. Rotho, was passed in this case earlier, and as many as 18 orders have already passed, and the last order is dated 9/10/2023. That was order number 18. As per order dated 16/8/2023, London Council for the State has produced the status report dated so of the inspector in charge of Khandagiri police station, which indicates that various steps have been taken by them to trace out the victim as well as the accused. The status report is taken on record. MD Jamshed, Sub-Inspector of Police of Khandagiri Police Station with the investigating officer is present. Land Council for the petitioner submits that after 12 days, the victim would attain the age of majority. Land Council for the state submits that the matter may be taken up after ensuing puja holidays, so that she will file the up-to-date status report. Okay, so any progress made, because at that point of time there was apprehension that since she was just to complete the 18 years, once she comes out, she may be. So now she has completed 18 years as per the date of birth. So
Yes, sir.
any development made, whether she has been traced out?
Not yet traced out, might be the first time.
Traced out.
Not traced out.
And
IO is present.
what about that boy who is alleged to have taken her? Aguti asundu mic purpose. ସେ ଏ ଯୋଉ ଏତଲାରେ ଯୋଉ ପିଲା ନାଁଟା ଲେଖା ମାନେ ଆପଣ ତ ଅନନୋନ୍ ଏତଲା ହେଇଥିଲା, ତାପରେ ଆପଣ ଜାଣି ସାରିଲେଣି ସେ ପିଲା କିଏ?
ଲକ୍ଷ୍ମୀଧର ବାରିକ ସେ
କୋଉଠିକାର ସେ?
ଖଣ୍ଡପଡା
ଆଁ?
କାଦୁଆ ଖଣ୍ଡପଡା
ସେଇ ତାରି ଗାଁ ପିଲା, ଝିଅର ଗାଁ
ନା।
ପିଲା, ଆଉ ଅନ୍ୟ ଗାଁର କଣ ସେ ପିଲା କରେ?
ଏଠି ସେ କାମ କରୁଥିଲା ପଞ୍ଚର ରହିକି
ଆଚ୍ଛା,
ସୋରୁମରେ କାମ କରୁଥିଲା।
ତାର ସେଠିକାର ପରମାନେଣ୍ଟ ରେସିଡେନ୍ସ? ଆରେ ସେଇ ଯୋଉ ଖଣ୍ଡପଡା ନା କଣ କହୁଛନ୍ତି? ତା ବାପା ମା କଣ କରନ୍ତି? ବାପା କଣ କରନ୍ତି?
ଭାଇ ଚାଷବାସ କରନ୍ତି।
ଚାଷବାସ କରନ୍ତି। ସେମାନଙ୍କୁ ତାଙ୍କୁ ପଚରା ପଚରି କରିଥିଲେ, ଆଉ ତାଙ୍କ ରିଲେସନ ଘରକୁ ଯିବା ଆସିବା ଯାଇଥିଲେ, କଣ ହେଲା କିଛି ଜଣା ପଡିଲାନି? ତାଙ୍କ ସାଙ୍ଗରେ କଣ ପୁଅ ଲିଙ୍କ ରଖୁନି?
नली को ଆମେ CDR ଫିଡିଆର ସବୁ ମୋବାଇଲ ସର୍ଚ୍ଚ କରୁଛୁ ଚିଲିଂ ଜଣା ପଡୁଛି
ହୁଁ
CDR ମଗୁଛୁ ମୋବାଇଲ ସବୁ ସର୍ଚ୍ଚ କରୁଛୁ।
ତ ଆପଣ କହୁନାହାନ୍ତି ଯେ ତାଙ୍କୁ ଆସ୍ୟୁରାନ୍ସ ଦଉନାହାନ୍ତି ଯେ ବର୍ତ୍ତମାନ ଝିଅ ଯଦି ସାବାଳିକା ହେଇଗଲାଣି, ଯଦି ସିଏ ବର୍ତ୍ତମାନ ଆସିବ ଏବଂ ତା ସ୍ୱଇଚ୍ଛାରେ ସିଏ ଚାହିଁବ ବାହା ହବା ପାଇଁ ମଧ୍ୟ ଆପଣଙ୍କର ପୁଅକୁ, ତାହେଲେ କିଛି ଆଇନଗତ କିଛି ଅସୁବିଧା ନାହିଁ। ଏ ପ୍ରକାର ତାଙ୍କୁ କନଭିନ୍ସ କଲେ ହୁଏତ ପୁଅ ଝିଅର କଥା ମିଳିପାରେ।
ମୁଁ ତାଙ୍କ ବାପାଙ୍କୁ କନଭିନ୍ସ କରିଥିଲି।
ହଁ
ସେ ତାପରେ ମୋବାଇଲ ସୁଇଚ୍ ଅଫ୍ କରିଥିଲେ।
ହଁ
ତାପରଠୁ ମୋବାଇଲ ସୁଇଚ୍ ଅଫ୍ ତମର
ତାପରଠୁ
ମୋବାଇଲ ସୁଇଚ୍ ଅଫ୍ ବାପା
କାହାର ମୋବାଇଲ ସୁଇଚ୍ ଅଫ୍?
ପୁଅର ବାପା ମଧୁବାରୀ
ପୁଅର ବାପା ମୋବାଇଲ ସୁଇଚ୍ ଅଫ୍ କରିଦଉଛି, ଆପଣ ଯାଇପାରୁନାହାନ୍ତି ତା ପୁଅ ବାପା ଥାନାରେ ବସି କଣ ଫ୍ୟାନ ଗରମ ହବ ବୋଲି ଯାଉନାହାନ୍ତି ନା କଣ?
ତାପରେ ଅନ୍ୟ କଣ୍ଟାକ୍ଟ ଚାଲିଛି,
ହଁ
ଅନ୍ୟ କଣ୍ଟାକ୍ଟ ଚାଲିଛି ଆସିପାରିବ।
ବାପା ଆପଣଙ୍କୁ କହିଲା, ଆପଣ ଏଇ ଯୋଉ ଆସ୍ୟୁରାନ୍ସ ଦେଲା ପରେ ବାପା କହିଲା ଆପଣଙ୍କୁ ବୁଝି କହିବ, ତାପରେ ଆପଣ ଥାନାରେ ବସିକିନି ଫୋନ କଲେ ସେ ସୁଇଚ୍ ଅଫ୍ କରିଦଉଛି, ଆପଣ ଚୁପଚାପ ରହିଗଲେ ଚାଲିଗଲେ ଏଠିକି ଷ୍ଟାଟସ୍ ରିପୋର୍ଟ ଗୋଟେ ଫାଇଲ କରିଦେଲେ। ହଁ
ଅନ୍ୟମାନଙ୍କ କଣ୍ଟାକ୍ଟ ଚାଲିଛି, ଅନ୍ୟ ଯୋଉ ଭଦ୍ରଲୋକ ଅଛନ୍ତି।
why didn't you take his father?
ଆରେ ଆପଣ ଯୋଉ ଜିନିଷଟା କହିଥିଲେ ତାଙ୍କୁ ଯାଇକିନି ତା ଘରକୁ ଯାଇ ପଚାରିଲେନି ଯେ ଫୋନ କଣ ସୁଇଚ୍ ଅଫ୍ କରୁଛୁ, ମୁଁ ଇନଭେଷ୍ଟିଗେସନ ଚାଲିଛି, ତ ଏଇଆ କୁହାହେଇଥିଲା, whether you have communicated this to your son or not, ଏକଥା ପଚାରିନାହାନ୍ତି କାହିଁ ଆଜି ପର୍ଯ୍ୟନ୍ତ?
ପଚାରିଛି,
କଣ କହିଲା ସେ?
ସେ କହିଲା ମୁଁ ବୁଝି କହିବି କରିବି କହୁଛି।
And you allowed him?
ସିଏ ତ ମାନେ ଆପଣଙ୍କୁ ଏସପି ଭଳିଆ କଥାବାର୍ତ୍ତା କରୁଛି ନା, ହଁ ମୁଁ ବୁଝିକି କହିବି। ୟୁ ଆର୍ ପୋଲିସ ଅଫିସର। Somebody's daughter has been kidnapped, a minor daughter. Now she has attended majority. Of course, she has right now to stay at her own choice at any place with anybody. But that doesn't mean that you will not try to sincere step to trace her out. Mr. You are the IAC?
ଆୟୁ
Now we are. When you have given that assurance to the father that nothing will happen if the boy and the girl now comes, କେବେ ତାଙ୍କୁ କହିଲେ 18 ବର୍ଷ ପୁରା ହେଲା ପରେ ତାଙ୍କୁ ଯାଇକିନି କହିଥିଲେ ଯେ ବର୍ତ୍ତମାନ ଆସିଲେ ସେମାନଙ୍କର କିଛି ଅସୁବିଧା ହବ ନାହିଁ? କେବେ କହିଥିଲେ? 22/10 ରେ କହିଲେ, ତାପରେ ଆଉ ବାପାଙ୍କୁ ଦେଖା କରିନାହାନ୍ତି?
ସେ ଖୋଜି ତାକୁ ଡାକୁଛି ଆସିନି।
ବାପା କହୁଛି ମାନେ ମୁଁ କହିଦେବି, ଜଣେଇଦେବି ମାନେ that indicates that the father has contact with the boy and he knows where the boy is. And if you would have taken pain to verify the call detail report, you could have noticed that from which source the phone is coming to the father. ବାପା ଯଦି କୋଅପରେଟ କରୁନି ଏ ବାଟରେ ଜାଣି ହେଇଥାନ୍ତା ନା ନାହିଁ? ଯଦି ବାପା କହୁଛି ମୁଁ ଜଣେଇଦେବି ଏ ବିଷୟରେ, ପୁଅକୁ ଜଣେଇଦେବି, ତାମାନେ ବାପା ଜାଣିଛି କୋଉଠି ପୁଅ ଅଛି?
ବାପା କହୁଛି ମୁଁ ଜାଣିନି କୋଉଠି ଅଛି।
ଜଣେଇଦେବି କେମିତି କହିଲା?
ନାଇଁ ଯୋଉ ବୁଝି କହିବି।
କଣ ଆପଣଙ୍କୁ ସେ ଭୁଆଁ ବୁଲଉଛି, ଆପଣ ଇଏ କରୁଛନ୍ତି। Mr. Tripathi, let somebody else investigate this matter.
IAC will take IAC personally.
IAC no. ಈ ವೇತನ ನಾ ಇವ್ರು ಕಾಣಲೆ. Right. Mr. MD Jamshed, SI of Police, Khandagiri Police Station, is present. Status report has been filed by IIC, Khandagiri Police Station, Bhubaneswar, UPD. It appears that the victim girl has now attended majority. The IO, who is the investigating officer, it like the Swanso, who is the investigating officer of Khandagiri PS case number 95 dated 22 to 2022, is present. The IO submitted that he had given assurance to the father and family members of the boy. Tana kaun se pila na? Huh? Bracket opposite party number 10. That if the boy and girl now return, there would be no problem for them. And in spite of such assurance given, the whereabouts of the boy and the victim girl, whereabouts of the opposite party number 10 and the victim girl could not be traced out. After having interaction with the investigating officer, we are not satisfied the manner in which the investigation had been carried out so far. Let the inspector in charge himself investigate the matter and try to locate the victim as well as the accused, and let the DCP Bhubaneswar hand over the charge of investigation to the inspector in charge of Khandagiri Police Station, Bhubaneswar, UPD, and instruct him specifically to trace out the victim girl as well as the opposite party number 10 from their hideouts, and matter be listed in the week commencing from today is 6th, we are keeping it on 20th. So 20th of November 2023, the Learning Council for the state shall apprise us about the up-to-date development made. In the meantime, the inspector in charge of Swanso shall remain present on the next date. A free copy of the order be handed over to the Learning Council for the state. Yes, next case.
Item 11.
May I please, Your Lordship? In this case, Your Lordship, the victim girl is 15 years, Lordship. Last occasion, Your Lordship directed the ISC Pulbani Police Station to remain present because the victim has not been traced out still yet, Your Lordship.
As per the status report received from the IIC Town Police Station, Fulbani, with some documents regarding steps taken by the IO to rescue the victim girl. Though the FIR indicates the name of the accused, but it is mentioned in the report that family members, including the parents, did not divulge anything during their examination. Rather, their house was found locked and the mobile numbers were switched off. Submitted on all anxieties with petitioners approach the police to know the whereabouts of so and so. Oh, this is that case where the allegation is that they misbehaving.
Yes, Your Lordship.
If the submission of this one so is found to be correct, then it is very unfortunate state of affairs one. Therefore, it is okay. Then they expected the Swanso to behave with the properly in a dignified manner, give all kinds of support and assistance, and also provide information to them regarding the steps that have been taken by the police to rescue the victim girl. The inspector in charge of town police station Fulbani is directed to appear before Swanso. Up to that, yes. You are the IAC of town police station Fulbani.
Sir, sir.
So this is the way the public expect your behavior when they approach you for at the time of their need.
सर ମୁଁ 21/9/2023 ରେ ଜଏନ୍ କରିଛି sir. Previous ରେ ଅଶୋକ କୁମାର ଗିରି ଥିଲେ sir. Inspector ଥିଲେ sir.
What you have done after this order was passed? You have lost the FIR on what date?
25/11/2022, Your Lordship.
So you have named the accused.
Yes, Your Lordship. OP number 4 is
So what happened to that opposite party number 4? ସେ ଯୋଉ ସୀତାକାନ୍ତ ଦିଗଲ ସେ କଣ ଏପର୍ଯ୍ୟନ୍ତ he is also found missing.
Sir, sir.
ତା ଘର ଲୋକ କଣ କହିଲେ?
ସେ ଘର ଲୋକ ଜାଣିନାହାନ୍ତି କହୁଛନ୍ତି।
ଝିଅର ବୟସ ବର୍ତ୍ତମାନ ମାଇନର।
minor.
କଣ ଆପଣ ସବୁ steps ନେଲେଣି to know that କୁଆଡେ କୁଆଡେ ଆପଣ ଯାଇକିନି ତଦନ୍ତ କଲେଣି କାହା ଘରକୁ ବା କୋଉ ଜାଗାକୁ ତାଙ୍କୁ ଦେଖିବା ପାଇଁ?
ତାର ବାପା ମାଙ୍କୁ ବି ସାର୍ ଇଣ୍ଟରଗେସନ କରାଯାଇଥିଲା ସାର୍, ପଚରା ଉଚରା କରିଥିଲା, ସେମାନେ କିଛି କହିପାରୁନାହାନ୍ତି।
ବାପା ମାନେ ସେଇ ପୁଅର?
ସାର୍ ଆଉ ତାର ରିଲେଟିଭ ଘର ସେ ରାଇକିଆ ବାଲିଗୁଡା ଇଏରେ ତାଙ୍କ ରିଲେଟିଭ ଅଛନ୍ତି, ସେଇ ଜାଗାରେ ମଧ୍ୟ ସର୍ଚ୍ଚ କରାଯାଇଥିଲା ସାର୍, କିଛି କ୍ଲୁ ମିଳିଲାନି ସାର୍।
ସେଠି ମିଳିଲାନି ମାନେ ସେଠି ଆସିଥିଲେ କି ନାଇଁ?
ନାଇଁ ସାର୍ ମନା କରିଛନ୍ତି ସାର୍। ସେ ଭୁବନେଶ୍ୱର ବି ଗୋଟେ ଜାଗାରେ ଆମର ଆଇଓ ଆସିଥିଲା ସେ ସର୍ଚ୍ଚ ରେଡ୍ କରିବା ପାଇଁ, ସେ ଜାଗାକୁ ସସ୍ପେକ୍ଟ ଆସିଥିଲା ବୋଲି ଶୁଣା ଯାଉଥିଲା।
You are having the photograph of the boy and the girl with you?
Sir, sir.
Okay. So locality भी केही किछ कहि पारलेनी? Then no phone call is coming from the boy to the
CDR analysis LIV नहीं आया सर, किसी तरह 25/11/2022 रे सर यूज करी 26/11 रो और टोटली से यूज करू सर।
25/11/22
22 सर 25/11/2022 सर।
That means phone is switched off perhaps. That phone is not authorized.
मोबाइल घरे छाड़ी सर।
ओ मोबाइल घर छाड़ दिए। झियोर किसी मोबाइल नंबर नथिला? घरକୁ ସିନା ଫୋନ କରୁନି ତା ଫ୍ରେଣ୍ଡ सर्कल କାହାକୁ ଇଏ କରୁନି ସେ?
टाइप इंटरसेप्शन नहीं आया सर, किंतु किसी सस्पेक्ट आसिल सर आ फर्दर करिजु सर फ्रेंड सांग गुडा को एलाइन नबा ପାଇଁ।
ଆଉ बैंक अकाउंट हेरिया ट्रांजैक्शन किछि हिनी को
ट्रांजैक्शन है सर, स्टेट बैंक गोटे अकाउंट अछि सर, किछि
सर गोटे अकाउंट अछि स्टेट बैंक रे, सेटु किछि ट्रांजैक्शन हिनी? So, Mr. Das, you are granting some further time proceed. What is your good name?
सर कनक कुमार माझी सर।
लिखिन दियो urgent slip दी दूं से लिखी दे। So also the inspector in charge of Model Town Police Station Khulbani is present, and he submitted that he had taken over the charge of investigation since केबे टुनेले
Sir, se previous ayo ଅଛି sir
ନା,
ମୁଁ
କେବେ ନେଲେ?
ଆପଣ କେବେ ନେଲେ ଚାର୍ଜ ଅଫ ଇନଭେଷ୍ଟିଗେସନ?
sir ମୁଁ ଇନଭେଷ୍ଟିଗେସନ ଚାର୍ଜ ନେଇ 21/9/2023 ରେ ଜଏନ୍ କଲି sir ଫୁଲବାଣୀ ଟାଉନ୍ PS।
That he has joined the IIC on 21/9
sir 2023
21/9/2023, and who is now investigating this case?
SI ରଞ୍ଜିତା ବେହେରା sir
And SI Ranjita Behera
ବେହେରା sir।
is now investigating Pulbani Town PS case number 203 of 2022, registered under section 363 of the Indian Penal Code. It is submitted by the IIC that in spite of sincere effort being made to trace out the opposite party number 4, who is alleged to have kidnapped the minor daughter of the petitioners, the whereabouts of the victim and the opposite party number 4 could not be ascertained. And the relatives' house have been of the opposite party number 4 has been searched, and the mobile phone, the opposite party number 4 has left the mobile phone in his house, and there is no transaction in the bank account of the opposite party number 4 in the SBI. However, it seeks some further time to proceed with the investigation of the case and to apprise this court about the development made in the meantime. Put up this matter in the week commencing from 4th December 23. We are granting one more month to you, so you submit the status report on that day and remain present. Free copy of the order be handed over to you. Yes.
Item 12.
Petitioner's minor daughter has been kidnapping since the month of March. Today is for personal appearance of the IIC Rajkanika case.
Let it tomorrow.
Tomorrow. All right. It will be called tomorrow from this weekly list, okay? So 7/11/2023. Yes.
Item 13.
The minor girl is missing from 18 to 2023, Lordship. Last occasion, the IO has present before your Lordship.
Receipt from so regarding steps taken by the same is taken on to mention the status report that intimated to have collected information from one of the friends who is staying at Hyderabad. Victim married the affair named accused after their elopement, and they were staying Hyderabad. So SI of police with the investigating officer is present and he submitted that he has received information that some of the relatives of the accused are staying at Hyderabad, and the accused is changing his location from time to time, so also the SIM cards. He further submitted he took over the charge of investigations on queries made to the whether he had visited the Hyderabad to trace out the victim as well as the accused. He answered in the negative. Let the investigating officer and team constituted by the so-and-so visit Hyderabad to trace out the victim and also the accused by collecting all names and address and location, phone numbers of the relatives of the accused who are said to be residing there. Meantime, if the victim tries to contact the petitioner, and they should intimate the same son. And as per the certificate from victim was minor. अच्छा आपनको आउ विक्टिम कांटेक्ट करथिला कि तब आपन करनथला हां आपन कोन करले आ भितरे ऑर्डर हला परे what you have done after the passing of the order dated 9/10/2023, what you have mentioned in your status report aguru kon heichi, it is already we have noted down. We gave you said to visit that Hyderabad, and SP has to send a team to that visit that place with all the relatives' house who are staying at Hyderabad and to ascertain whether the boy and the girl had ever come to that place and stayed there or not. So how far you have carried out the order of this court?
Sir, ବର୍ତ୍ତମାନ କୌଣସି ପ୍ରକାର ସାର୍ ଆଉ ତାକୁ ଲୋକେଟ୍ ସାର୍ କରିହେଲାନି।
ମାଇକ୍ ଟାକୁ ଟିକେ ଆଡଜଷ୍ଟ କରନ୍ତୁ। ଆପଣ ମୋର ପ୍ରଥମ ପ୍ରଶ୍ନ ହଉଛି ଅର୍ଡରଟା ହେଇଥିଲା let the investigating officer and a team constituted by the superintendent of police Baleshwar visit Hyderabad to trace out the victim. Have you visited the Hyderabad in the meantime or not?
No, sir.
Why not?
Sir, team sir ready ହେଇଥିଲା ସବୁ ପ୍ରୋସେସିଂ ସରିଥିଲା କଣ ତାର ଲୋକେସନ କୌଣସି ପ୍ରକାର ସାର୍ ପାଇଲିନି ମୁଁ ଯୋଉ କୋର୍ଟ କି ତାର
ଆପଣ କଣ ଅର୍ଡରଟା କଣ ହେଇଥିଲା ଯେ ଆପଣ ସମସ୍ତ ଯେତିକ ରିଲେସନ୍ସ ରହୁଛନ୍ତି ସେମାନଙ୍କର ନେମ୍ସ ଆଡ୍ରେସ ଲୋକେସନ ଫୋନ ନମ୍ବର୍ସ ଏଗୁଡାକ କଲେକ୍ଟ କରିବେ କାହାକୁଟା ନା ଆକ୍ୟୁଜ ଫ୍ୟାମିଲିଠୁ କଲେକ୍ଟ କରିକିନି ଆପଣ ଯିବେ ଫଟୋ ସହିତ ଆପଣ ଯାଇଥାନ୍ତେ ସେଠି ପଚାରିଥାନ୍ତେ ଲୋକାଲିଟିରେ ପିଲାମାନେ ସବୁ ଏଠିକି ଆସିଥିଲେ କି ନାହିଁ ରହୁଥିଲେ କି ନାହିଁ ନଗଲେ ଏଠି ବସିଲେ କଣ ହବ?
ସାର୍ ମୁଁ ଫୋନ ନମ୍ବର ସବୁ କଲେକ୍ଟ କରିଛି ପ୍ରାୟ 10ଟା ଖଣ୍ଡେ ଫୋନ ନମ୍ବର କଲେକ୍ଟ କରିକି ସବୁଗୁଡା ଶୋଇଯିବ ତାର ଲୋକେସନ କୋଉଠି ଜଣା ପଡିଲା ନାହିଁ ବର୍ତ୍ତମାନ ସାଇବର ସେଲ୍ କହିପାରିଲାନି ଯେ ସେ କୋଉଠି ସେ ତାର ଲୋକେସନ ପ୍ରେଜେଣ୍ଟ ଲୋକେସନ କୋଉଠି କହିପାରିଲାନି।
ଆରେ ପିଲା ଝିଅର ଛାଡି ଦିଅନ୍ତୁ ତାଙ୍କ ରିଲେଟିଭ୍ସ ହାଉସ କୁ ଯୋଉ ସେ ରିଲେଟିଭ୍ସ ହାଉସ ରେ ସେ ପିଲା ଆଉ ସେ ପୁଅ ଆଉ ଝିଅ କେବେ ଆସିଥିଲେ କି ନାହିଁ କେତେ ଦିନ ସେଠି ରହିଲେ ସେପାଟେ ବୁଲାବୁଲି କରୁଥିଲେ ନାହିଁ କଣ କରୁଥିଲେ ଏସବୁ ଜିନିଷ ଜାଣିବା ପାଇଁ ଆପଣ ଯାଇଥାନ୍ତେ ଏଠି ବସିକିନି ଫୋନ ସିଏ ଦେଇଦେଲେ ଆପଣ ଫୋନ କଲେ ସେ ସୁଇଚ ଅଫ୍ କଲା that is not the order. The order is that you are to collect all the relatives phone number their address and you visit that place Hyderabad spot ku jaithante and a team not only you but the team should that is to be constituted so you have not carried out the order.
Pardon, Lordship. As per the instruction, another co-accused Sudhanshu Shekhar Sethi alias Baki, the last second
third page.
So he surrendered before he appeared before the IO,
sir,
and made an assurance to ensure the presence of the accused,
sir.
But he did not. But he is still appearing before you,
sir.
In the order in ABLAPL, he has been asked to appear before you. So he is appearing before in the police station. So what happened to his assurance?
ସେ ସାର୍ ଏସଏନ୍ସ ଗୋଟେ ରିଟର୍ନ ଲେଖିକି ମୋତେ ଦେଲା ଯେ ମୁଁ 4 ଦିନ ଭିତରେ ମୁଁ ଟ୍ରେସ୍ କରୁଛି ମୁଁ ତମ ଫ୍ୟାମିଲି ମେମ୍ବର ଫୋନ ନମ୍ବର ସବୁ ମତେ ଦିଅ ଯିବା ସେଠିକୁ ମତେ ଫ୍ୟାମିଲି ନମ୍ବର ଫୋନ ନମ୍ବର ଦିଅ କହିଲା ମୁଁ ଫୋନ ନମ୍ବର କଲେକ୍ସନ କରି ଦଉଛି ନା ଯୋଉ ଫୋନ ନମ୍ବର ଦଉଛି ସେ ଫୋନ ନମ୍ବର ଶୋଇଯିବନି ଲୋକେଟ କରିହେଲାନି ତା ଇଏ।
But the question is that why have you not carried out the order passed by this court?
Sir,
yes, why your SP has not sent them? ଏଠି ବସିକିନି ସ୍ପଟ କୁ ନ ଯାଇ ଯୋଉଠି ସେମାନଙ୍କର ପସିବିଲିଟି ଅଛି ସେମାନେ ରହୁଛନ୍ତି ବୁଲୁଛନ୍ତି ସେଠିକି ନ ଯାଇ ଏଠି ଓଡିଶାରେ ବସି ଆପଣ ଫୋନ ନମ୍ବର କଲେକ୍ଟ କରି ଫୋନ କରିବେ ସେ ସୁଇଚ ଅଫ୍ କରୁଛି this is not the order which you have passed. Have you not got the copy of that order, Mr. Das?
My lord.
So you come to the page number 2
yes,
and
I have gone.
So it's a clear case of contempt. Clear case of contempt. To ask the SP to take immediate steps, or otherwise he will face the niceties of law. There is a specific order you have not
carried. Specific order, and on that ground, the last time, my lord, granted time. Because last status
now se co-accused ko ji mu ani dei devi phone number tang gote kon dei douchi ye phone kor douchandi seti nahi kichi tapre chupcha bas jauchandi se puni a gote number dei douchi bas.
Another co-accused Ramani Sethi and Ranjan Sethi also gone to Hyderabad with Sudhanshu Sethi. Lordship, page number 2, second para ro last portion को अछि ସେମାନେ
accused को धरिकिन से जो माने आसिलेनी तांको धरिकिन जांतु स्पॉट को से माने सेठी गले सिना स्पॉट रे किछि आपण पाइबे से विषय रे एठी फोन ने बसी थाना रे बसी गेले कोन हबो Mr. Das, you ask the SP immediately to constitute the team and send the IO with that team and comply that order. You are the, what is your name, Tanu? You are the SI of Sadar Police Station, Baleswar.
Sir.
You are the investigating officer.
Sir.
So and so with the SI of Police of Sadar Police Station, Baleswar, and the investigating officer of Baleshwar Sadar PS case number 61 dated 1/3/2023 is present and he has filed the status report. On 9/10/2023, inter alia, we passed the following order. You late to see good paragraph खाली quote कर देंगे. Hala page number 2 रे अछि. Let the investigate है ना. When we put a pertinent question to the IO whether he has visited the Hyderabad along with the team which was to be constituted by the Superintendent of Police Baleswar to trace out the victim and also the accused. He answered in negative. Therefore, our order dated 9/10/2023 has not been complied with. However, the Learned Counsel for the state submitted that after receiving the copy of the order dated 9/10/2023, the same has already been sent to the concerned authority and some further time may be granted so that the Superintendent of Police Baleswar shall take necessary steps in accordance with the order dated in compliance the order dated to comply the order dated 9/10/2023. In view of such submission, list this matter in the week commencing from 4th December 2023. The investigating officer shall remain present in the meantime. It is made clear that if the order dated 9/10/2023 is not complied with in the meantime, this court will be constrained to initiate a proceeding for contempt of courts act against the erring officials. Yes, free copy of the order be handed over to the Land Council for the state.
Item 14.
Item 14, Lordship. In this case, the minor girl aged about 15 years, Lordship.
Who?
Minor,
Who is
minor girl,
victim?
victim
Yes.
has been kidnapped. And
You were in 14.
Lordship.
Oh,
And
all right.
item 14, Lordship. And since then, he has not been.
The order which was passed on 9/10/2023, Bhuvana Mohana Sethi, officer in charge of Singla Police Station, is present. He has filed the status report. Mentioned in the status report, so and so. Yes, investigator instituted on the first information. The house of the accused, also the relatives of the village, so and so, in the district of West Bengal, are searched. Patients of the but both the victims were found absent. Case diary produced before this court, it is found that there is no documentary evidence except mentioning in the case diary regarding visit to so and so. The officer in charge submitted that one SI Kailash Chandra Mahalik is the investigating officer of the case and attempts have been made to rescue the victim girl as well as to trace out the accused, and it is expected that they would succeed in the mission very soon and some time may be granted in that respect. Okay. So what development has been made? कौन किछि हेला सक्सेसफुल हेले ना नहीं किछि
ନା ସାର୍ କିଛି ବର୍ତ୍ତମାନ ଆସୁନି ତାର ଲୋକେସନ କିଛି ଆସୁନାହିଁ।
कौन कले ऑर्डर पास होला परे आपण प्रा से दिन एश्योरेंस देई गले
ସାର୍ ଆସିଥିଲେ
आपण से दिन कहिले जे कैलाश चंद्र मल्लिक होचन इन्वेस्टिगेटिंग ऑफिसर आउ अटेम्प्ट्स निया होउची आउ आपण आशा करछन जे खूब शीघ्र आपण सफल हेबे आउ से झियो आ पुओ तांकर रेस्क्यू हेबे बोली तो से जो ऑर्डर पास होला ऑन 9/10/2023 so thereafter what progress you have made where have you stated that
ରିଲେଟିଭ ହାଉସରେ ଦୁଇ ଜାଗା ଯାଇକି ଦେଖିକି ଆସିଥିଲୁ ତାପରେ ତାର
आपण 9-10 परे कोन स्टेप नेइचंदी where have you mentioned गत थर जहा देइथिले ताकू कोन कॉपी पेस्ट करी देई देइचंदी ना
ନା
कोन
ସାର୍ ତାର ଲୋକେସନ ପୁଣି ମଗାଇଛି ସିଡିଆର ମଗାଇଛି ସାର୍ ଆଉ
where have you mentioned that what you have done after 9/10/23 we are putting a pertinent question we do not find anything from the status report which you are submitting today 9/10/2023 परे आपण कोन कोन करिसेंती आपण केस डायरी अछि
सर
देखिले 9-10 परे कोन करिसेंती आपण
18-10 रे search the accused person and victim कोठी victim in presence to witness but found absent in the
What is the food search gale
कोड गले कोन गले
बाली
बाली साई मेलो
huh
बाली साई
what is the corresponding document to that effect बालिसाई कोठी
सही सर एक्यूज करो सर
huh
एक्यूज
it's in a different police station under a different police station jurisdiction
ने सिंगला
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 सर
जाइथिले आपण
जय सर
निजे जाइथिले
आज्ञा
सर्च कले
आज्ञा
को दिन
On 18th.
18 सर
where is the corresponding document to that effect खाली केस डायरी लिख देले
ना सर जाइछ सर
जो गोटे जागा को जाई सर्च कले
आज्ञा
सर्च रे जदी किछि न मिलिला ता पई गोटे लिस्ट प्रिपेयर हुए ना नहीं
आज्ञा
कोन लेखा हबो किछि पाया गला नाही बोली लेखा हुए ना नहीं where is that document
आपण खाली ता घर सर्च करिया तो डिफरेंट डेटा तो किछ करना
respective persons of the locality को presence रे सर्च करा जाए आपण कोडी कोन करछन
केवल तारी घर सर्च करछन
there is a procedure laid down in the CRPC how do you have to search CRPC रे procedure अछि ना नहीं जते बळे सर्च करिया को जिबे केमती करिवे कोन मेंटेन करिवे ए सब जिंस अछि ना नहीं पुलिस मैनुअल रे अछि ना नहीं काहे से डॉक्यूमेंट काहे खाली लिखि देले ही जीवो की केस डायरी मु सर्च कली हमको किछि मिललानी हम तो थाना रे बसी आपण लिख दे आउ कोन करे से केस डायरी को आउ कोन देखु आउ कोन करछन
सर सर
बैंक डिटेल्स ता मागी चंदी
Bank details was earlier also asked for.
again पुन मागी चंदी
No transaction was there as been shown in 2022.
19-10 पुने ओटे रिक्वेस्ट करछन तांको पुने अच्छे न से भी क्लोज नाही किछ ट्रांजैक्शन
झियर बयस वर्तमान केते हला
18 ऊपर
ना
केते
कंप्लीट हे गेलानी
केते
हेनी what is the date of birth
डेट ऑफ occurrence से 15 वर्ष
date of birth ता कोना दिकेबे
28 February 2007.
डेट ऑफ बर्थ होची
28
February
2007 लॉर्डशिप
2007 ना you could measure a lot
Yeah, he's still married.
accused sorry 16 year 25
16 years months
accused 18 वर्ष
किसी फोन फान से घर को करूनी
ना सर
से झियो ता सांग फांग को किछ फोन फान करूनी रिलेटिव्स घर को गलेनी
आज्ञा
माने बाहर जो माने रिलेटिव रहउचंती ओडिशा बाहर किए रिलेटिव अछंती
accused ର ତାର
हाँ accused ର कौची आ कौन
ତାର ବଡବାପା ଅଛନ୍ତି କାକା ଅଛନ୍ତି ତାଙ୍କ ସହିତ କିଛି ଯୋଗାଯୋଗ ରହୁନି ତାଙ୍କର
कथा ହେଇଥିଲେ ଆପଣ
ଆଜ୍ଞା
बड़ा को एग्जामिन करछंती
ନା କରିନି
ଆଉ କେମିତି ଜାଣିଲେ?
कौन आपण की इन्वेस्टिगेटिंग ऑफिसर मु किछ बुझी पानी कि बड़ बापा को पचारुचंती गोटे ये रे गोटे केस इन्वेस्टिगेशन होउसी किडनैपिंग केस रे बड़ बापा स्टेटमेंट ही नहीं आपण को जन बड़ बापा एग्जामिन कली पचारली कौन एटा कौन प्राइवेट अफेयर ना यू आर एन इन्वेस्टिगेटिंग ऑफिसर को दिन टाइम लेखले सेटा लेखा जीवो केस डायरी एग्जामिन इन recorded statement in separate sheet तापर 161 रहिबो Yes, Mr. Das, we are not satisfied
Yes,
the
madam.
way this thing
Also,
are going
not a
on.
single statement also recorded.
So, virtually, you see,
that's all.
almost
Yes.
a month has passed. अब गोटे दिटा जगह जाइछन्ती बेल लिखा है which is not corroborated by any documentary evidence.
Right.
बैंक को जो कौन कहिथिले where is the document to that? बैंक को आपण
Bank
जो
अछि.
मगेले या भीतर अछि document.
बैंक अछि statement भी बैंक अछि but
So he is not furnishing any
नहीं बैंक भी रिप्लाई देछि statement transactions नहीं अकाउंट रो गोटे
no, या भीतर देछि
हां किछि एज क्लोज मतलब कुछि लास्ट मतलब
No, whether that information of the bank is of the year 2022.
Just a minute.
Please verify because we want that he says that after 9, 10, 23 we are specifically asking
My lord 25/10 रो मैडम
हां तापर रिप्लाई कोन देला बैंक
1/1/2022 ରୁ 25/10/2023 पर्यंत सन ट्रांजैक्शन गोटे स्टेटमेंट देछन्ते
हां
जोतरे कि लास्ट ट्रांजैक्शन my lord सो कोछि 25/6/2022 रो
Yes.
ओहो अच्छा Are you sure that you will succeed in some you want for the time?
ଆଜ୍ଞା
Take it as a challenge when you are coming to this court and if you succeed your future is bright. So why are you spoiling it? क्या बसीगले केमती हबो केते मॉडर्न टेक्नोलॉजी बाहरलानी केते कोन ये से विषय रे जानिबे अन्य मानक पचारिबे केमती सब से देयर इज ए फोरम आल्सो ताकू यूटिलाइज करिकिन आपण बाहर करिवे जो जोड़ा को करूचंती केस डायरी लेखुचंती आईन अनुଯାयी केमती तार डॉक्यूमेंटरी प्रूफ रहिबो काल सकाळे आपण को खाटगडा रे छिडाबो डिफेंस काउंसिल जेरा कर दी चली जीवो आपण किछि पचारि परिबे एई प्रश्न जोड़ा को मु पचारुची सेई प्रश्न पचारिबो आपण कहिथिले जे घरु जाइचंती कोन डॉक्यूमेंट अछि चुप नाटा लिखिन sworn so the SI of
Yes.
SI of Singla police station is present and he submitted the status report of the case. It is taken on record. After verifying the case diary regarding the progress of the investigation, after passing of the order dated 9/10/2023, we are not satisfied the manner in which the investigation has been carried out. However, the investigating officer submitted that he will make all sincere effort to trace out the victim and the accused who is alleged to have kidnapped the minor girl of the petitioner and some more time may be granted. Put up this matter on the 4th December 2023. 4 तारीख रे रहिला आपण आसीबे चले appear before this court. Status report is taken on record for the
Item 15.
On 15, my lord, I am marshalling my detention in custody. Your lordship will permit me. I will be filing a note, my lord, and through note I will address your lordship. I have given the sequence of events, my lord. Let a copy be handed over to the Mr. So Mrs. Patna, you go through it. We can take up tomorrow. If he's
I have
some,
filed a counter, my lord. I've already filed a
I
counter.
think
no,
Exhaust.
today he's handing
Yeah,
over.
এটা দেখি কি
हाँ, এটা
date chapter days.
It's all right. Let her go through it. We can take up tomorrow because this list is for entire week. Let her go through. We will also go through it. We can take up this matter tomorrow.
Tomorrow?
हाँ, काली ये weekly list to नहीं आएगी. हेलो?
Item 16.
प्रमोद कुमार जेना. Password तो काली तो काली. এটা কাল দেখি 7, 11, 20, 23. Yes.
Item 17.
Hello, I'm for the OP, my lord, in this case, my lord. Son is my mother, the opposite part number 3. I am for the mother, my lord. Now, minor, number 6, my son with pro.
No, this what is the prayer made in this shall not be directed to recover opposite party number 6 from the custody of opposite party number 1 and 2 and hand over to
dispute between the husband and wife, my lord. The son with my, I am for the wife. Son, minor son, my 6 year my minor son. They have another prayer. There is nothing there, my lord. Paragraph 8 and
No. When the matter was last taken up on 25/9/2023, you said that the mediation is going on.
Yes, my lord.
And the parties are also appearing before the mediation center.
Both parties.
And the matter is to be date is fixed to so and so. So what happened in the mediation?
Mediation fell due to they have study of the student child, my lord, at Bhubaneswar, SHRI International. Session already over, my lord.
ଆପଣ ହଉଛନ୍ତି
mother with the all father-in-law, mother-in-law.
ପୁଅ ନା ଝିଅ ଆପଣଙ୍କର?
ମୋ ପାଖେ ପୁଅଟି ଅଛି. OP number 6 ଆଜ୍ଞା. OP number 6. ସେ ତାର ପାଠ ପଢିବା ପାଇଁ କହୁଥିଲେ ସାଇନ୍ସ ନ୍ୟାସନାଲ ଭୁବନେଶ୍ୱରରେ. ଅଲରେଡି ସେସନ ଓଭର, ମାଇ ଲର୍ଡ.
ନାଇଁ ଆପଣ ତାକୁ ନେଇ ପିଲା ବର୍ତ୍ତମାନ କଣ କରୁଛି?
ଆଜ୍ଞା ସରସ୍ୱତୀରେ ପଢୁଛି.
କୋଉଠି?
ଆମର କଣ୍ଟିଲୋରେ. ସେ କହୁଥିଲେ ଭୁବନେଶ୍ୱରରେ
ସେ ତ ଅଛି ସାଇ ଇଣ୍ଟରନ୍ୟାସନାଲ ଅଛି, ହଷ୍ଟେଲ ଫ୍ୟାସିଲିଟିଜ ଅଛି, ଭଲ ଜାଗା.
ଛୋଟିଆ ଛୁଆଟା 6 ବର୍ଷ ଛୁଆଟି. 6 ବର୍ଷ ଛୁଆଟି, ସେ ରହିବ କୋଉଠି?
ହଷ୍ଟେଲରେ ରହିବ, ଯାଇ ଦେଖିବେ କଣ ଅସୁବିଧା ଅଛି. ସେ ଗାଁରେ ପଢେଇଛନ୍ତି, କଣ ସେ ହବ?
ସରସ୍ୱତୀରେ ଆଜ୍ଞା ପଢୁଛି.
ଆପଣ ଯାଇ ଦେଖା କରିବେ, ଇଏ କରିବେ, ତା ତତ୍ତ୍ୱ ନେବେ. ବାପା ତ କହୁଛନ୍ତି ପଇସା ଦବ ସବୁ.
ସେସନ ଓଭର ହେଇଗଲାଣି ଆଜ୍ଞା.
ହେଲା ଯେ
have you tried?
ହେଲା ପଢିବା ପାଇଁ ମୁଁ.
No, have you got the paper from the concerned school that since the session is over, we will not admit you?
ସେସନ ତ ଏମିତି ନଭେମ୍ବର ମାସରୁ କେତେବେଳେ ସେସନ ଓଭର ହୁଏ ଆମେ ତ ଜାଣିନୁ.
ନାଇଁ ଅଲରେଡି ଆଡମିସନ ସରିଲାଣି ଆଜ୍ଞା. ମିଷ୍ଟର ଶାନ୍ତନୁ ସିନିୟର
ଏକାଡେମିକ ସେସନ ଗୁଡାକ କେମିତି ନଭେମ୍ବରରେ
ନାଇଁ ଆରମ୍ଭ ଆଡମିସନ ସରିଲାଣି ଆଜ୍ଞା. ତାଙ୍କ ଇନଷ୍ଟ୍ରକ୍ସନ
ଯେ ନେବେନି ବୋଲି କହିଲେ କି ଆପଣଙ୍କୁ?
ନାଇଁ ଆମେ
ସେସନ ଇନ ଜେନେରାଲ ସରିଗଲା.
ସେ କହୁଥିଲେ ମତେ ଭୁବନେଶ୍ୱର ରଖିବା ପାଇଁ. କହିଲେ ଆଜ୍ଞା ମୁଁ ସ୍ତ୍ରୀ ଲୋକଟା ଭୁବନେଶ୍ୱର କୋଉଠି ରହିବି, କଣ କରିବି? ସେ ପ୍ରକାର ନହେଲେ ମୁଁ ତ ସରସ୍ୱତୀରେ ଗୋଟେ ପାଠ ପଢୁଛି, ନହେଲେ ନୟାଗଡ଼ ହେଲେ ବି ମୁଁ ରାଜି ଅଛି. ତାପରେ ହେଲା ବି ରାଜି ହେଲି, ଭୁବନେଶ୍ୱର ହେଲେ ବି ସବସିକ୍ୱେଣ୍ଟଲି.
So where is the council? So this
Mr.
Santanu.
किए एके नायक लिखा है ये कौन? S.K. Sahooo अच्छा. So ask the learned and senior advocate to appear, otherwise we'll close the proceeding. That has been placed. Now the boy is in the company of the mother. It cannot be said to be a case of wrongful confinement or illegal.
Yes, ma'am.
several occasions both are
It's all
present.
right, but just intimate Mr. the senior advocate.
After prefer after
After this is single bench.
sorry kal tomorrow. I intimate tomorrow.
All right, you kali now. 7, 11. Sorry. 7, 11.
ସିଏ ମୋ ଭରଣ ପୋଷଣ କିଛି ଦେବି ଦଉନାହାନ୍ତି.
Yes. ବାକି ଯାହା ଆପଣ ସେଗୁଡା that you can get in a different proceeding.
ଆଜ୍ଞା different.
Habeas corpus ଆପଣ maintenance ଦଉନାହାନ୍ତି, ଆପଣ ପୁଅକୁ ପଢେଇବେ, ସେ ଖର୍ଚ୍ଚ ଦଉନାହାନ୍ତି, that you will get in a different
Yes,
proceeding.
madam.
Yes.
Item 18.
18
Tomorrow. But the officers are present here.
Sir, sorry, madam. Sir, are you Chanpur?
Item 18, it is Prabhat Kumar Patro.
My lord. Lordship, can I have last to the Lordship's last order dated
14/9/23.
My lord.
Land Council for the state has produced the status report received from IIC Chandpur Police Station in the
Sorry,
district
madam.
of
Let it tomorrow. This is item 25.
7/11/2023. Okay.
Item 19.
May I please, Your Lordship? My lord. Until today, the victim girl has not rescued, my lord. She's a minor girl, my
Land
lord.
Council for the state has produced the report dated so-and-so of the inspector in charge Jaleshwar Police Station, from which it appears that after due analysis of the CDR and IME search, it was ascertained that the tower location of the said mobile number is Pune and the state of Maharashtra, and after taking prior permission, the IU along with the father of the victim went to Pune, conducted raid, the help of Ranjangaon police station so to trace out the victim, but the accused Akash Jina, OP5, and the victim girl absconded from the locality, evading police action. Further appears that the IO tried to trace out the victim through local sources and to track the location, but no fruitful result achieved so far. Frequent raids were conducted in relatives' house of the accused in Baleswar Bhadrak Mayurbhanj district. Okay, state seeks some time to obtain up-to-date instruction in the matter. What is your
Not yet rescued, man. This is a status report and the IO present.
After 25th. Status report after 25th of September.
Okay. Status yesterday.
Mr. Das and Mr. Tripathi, ଯେତେବେଳେ ଏଇ ସବୁ ଟାଇପ ର କେସ୍ ରେ ଆପଣ status report ଦଉଛନ୍ତି, ଆମ order ପରେ ଆମ order ରେ ଆମେ detail ଲେଖି ଦଉଛୁ, ତାପରେ ଆମକୁ କହୁଛୁ ଯେ ଆପଣ କଣ development, ସେ ପୁରୁଣା କଥା ଆଉ ଲେଖିବା ଦରକାର ନାହିଁ, ଏଗୁଡା copy paste କରିବା କି ଦରକାର ନାହିଁ, ତାପରେ ଯାହା development ହେଇଛି ଅର୍ଥାତ ଆମ order pass କଲା ପରେ ସେତିକି ହିଁ ଆପଣ ଦେବେ, ହେଲା, unnecessarily. Yes, so what progress you have made? This order was passed on 25/9/2023. तापरे केवल आपण देखिजंती on 28/9/2023 search in Baliapal police station area, and on 12/10/23 search in the house of Harendra Jana so and so, but in vain, on so and so SP Baleswar for legal interception of accused father so and so and relative so and so by same number related to the legal interception of the able mobile number is not activated till now. Our local sources engaged to rescue the victim girl. Here boys कितने हेलानी? Date of birth कितने?
1/3/2027, madam.
1
Sorry,
2027 or 7?
2007, madam. Sorry, madam.
1/3.
1/3, madam.
2007. So completed 16 years and 16 years, 7 months, 8 months.
Madam, Bappa, what happened, madam, is ମାନେ ଯିଏ ନେଇଛନ୍ତି ତାଙ୍କ ବାପା ଆସିକି ଆମକୁ ଧମକଉଛନ୍ତି ହାଇକୋର୍ଟରେ କେସ୍ କରିଛ ସେଟା ୱିଡ୍ର କଲେ ଯାଇକି ଆମେ ଆଣିବୁ ଘରକୁ।
Why you file FIR? Have you filed FIR again?
No man, ଫାଇଲ କରିନି ଲାଷ୍ଟ 2 days back my lord।
ଏମିତି କିଛି ଆପଣ କହିଥିଲେ ଯୋଉ
ନାଇଁ ମାନେ 2 ଦିନ ତଳେ ଫୋନ କରିଥିଲି ମୁଁ କହିଲେ ସେ ଆସି
ଇନ୍ସପେକ୍ଟର ଇନ୍ ଚାର୍ଜ କୁ ଜଣାଇଥିଲେ ସେ?
ମୁଁ ଆଜି କହିଦେବି ମାନେ ସେ ଜଣେଇଦେବେ।
ତ ୟୁ ଆର୍ ଦି ଆଇଓ।
ସାର୍
ତ ଏଇ ଟାଇପ ର ଇନଫର୍ମେସନ ଯଦି ଆସୁଛି ସେ କହୁଛି କେସ୍ ୱିଡ୍ର କଲେ ମୁଁ ଆପଣଙ୍କୁ ଖବର ଦେବି, ଦ୍ୟାଟ ମିନ୍ସ ଆଇଦର ହି ଇଜ ଟେଲିଂ ଫଲସୁଟ୍ ଅର୍ ହି ଇଜ ହାଭିଂ ଦି ଇନଫର୍ମେସନ ହ୍ୱେୟାର ଦି ବୟ ଆଣ୍ଡ ଗାର୍ଲ ଆର୍, ଆଇଦର ହେଇଥିବ। ତେଣୁ ଆପଣ ଏ ବିଷୟରେ ଯାଇକିନି କନଫ୍ରଣ୍ଟ କରନ୍ତୁ ଯେ ତମେ ଏଇ ଲୋକ ପଚାରିଲାଠୁ କଣ ଏମିତି କହୁଛ, ତମେ ପ୍ରକୃତରେ ସେ କହିଛି କି ନାଇଁ, ଆଉ ଯଦି କହିଛି ସେଥିରୁ କୋଉଠି ଅଛି କୁହ, ଏସବୁ ବିଷୟରେ ପତା ଲଗାନ୍ତୁ ତାକୁ ଆପଣ।
ସାର୍ 16/10
ହୁଁ
ମୁଁ ଡକେଇଥିଲି ଆକ୍ୟୁଜ୍ ଫାଦର ମଧୁସୂଦନ ଜେନା। ଡକେଇକି ପଚାରିଥିଲି, ସେ କହିଲେ ଯେ ମତେ 15 ଦିନ ସମୟ ଦିଅନ୍ତୁ। ମୁଁ
16/10 15 ଦିନ ତ ଗଲାଣି ଭାରି।
ହଁ ସାର୍ ଗଲାଣି, ତାପରେ ସାର୍ ସୁଇଚ୍ ଅଫ୍ କଲି। ମୁଁ ସାର୍ ଚେଷ୍ଟା କରୁଛି ଇଣ୍ଟରସେପ୍ସନ ଟା ହେଇଗଲି ସାର୍ 100%।
ନାଇଁ ନାଇଁ, ସିଏ ଯଦି ଆପଣଙ୍କର ଫୋନ କୁ ସୁଇଚ୍ ଅଫ୍ କରିକିନି ଆସୁନି, ଦେନ୍ ୟୁ ଭିଜିଟ୍ ହିଜ ହାଉସ୍ ହେଲା, ଏବଂ ଏ କଥାଟା ମଧ୍ୟ ପଚାରନ୍ତୁ ଯେ ପିଟିସନର କୁ କଣ ଏମିତି କହିଥିଲେ। ଇଣ୍ଟ୍ରୋଗେସନ କରିବାର କିଛି ମନା ନାହିଁ, ଏଇଟା ହଉଛି 2-3 ଦିନ ତଳର କଥା ସେ ଯୋଉଟା କହୁଛନ୍ତି। ତାମାନେ ମେ ବି ଦ୍ୟାଟ ହି ଇଜ ହାଭିଂ ଦି ଇନଫର୍ମେସନ ଅର୍ ହି ଇଜ just telling that somehow or other let the case be withdrawn from the High Court. Hala? Tenu, rather you say that the moment you bring out the boy and girl, there will automatically that case will be disposed of in the High Court. The type of assurance देइकिनी आपण बाहर करंतु ताको, हला तांको कथा हुए तो सुनिबेनी, आपण कथा सुनी पारंती जे ये जो केसटा फाइल ହେଇଛି आर उद्देश्य होची एति की आपण जे जानिछन जो मोमेंट रे पुओ झियो आसी जिवे काम सरला तो केस विल ऑटोमेटिकली सरी जिवो। तो the please give your name, Swanshu. You are the investigating officer of this of Jaleshwar PS case number 312 of 2023 is present, and he has submitted the status report filed by the presented Swanshu of the IAC Jaleshwar police station. The London Council for the petitioner submitted that 2 days back, the father of the accused intimated the petitioner that after the case is withdrawn from the High Court, he will inform him about the whereabouts of the victim girl. The investigating officer submitted that he had an interaction with the father of the accused on 16/10/2023, who assured that within 15 days he would try to give the whereabouts of the victim and the accused, but after passing of the 15 days, his phone has been switched off. He further submits that he will visit the house of the accused and interrogate the father of the accused, and also about the submission that has been made by the London Council for the petitioner today regarding the withdrawal of the writ petition. So we are giving you time till 4th of December 2023. We will come on that day. The status report is taken on record, put up this matter on 4th December 2023. Pre-copy of the order be handed over to the Land Council. So whenever you are getting any information, give it in writing. Okay, don't keep it to yourself. The IO is not aware that this progress has been made. He has assured you. He is searching at his own level. So you are to assist him. Okay.
Deeply obliged, my lord.
Item number 20.
Mr. Sunil Kumar Panda. This case also the victim rescued. Victim rescued. None appears for the petitioner. The learned counsel for the state has produced the written instruction received from IIC Body Ramchandrapur Police Station dated 5/11/2023, from which it appears that the victim has been rescued and she is now staying with her husband and maintaining a peaceful life. This compliance report is taken on record. The writ petition stands disposed of.
Item number 21.
The victim girl rescued.
Report achi ki? Acha. The learned counsel for the petitioner submitted that he has received instruction that the victim girl has been rescued. In view of such submission, WPCRL stands disposed of.
Item 22.
May I please do so? Last occasion you also give direction to file a affidavit. As per the
last order is 9/10/23.
Yes, my lord.
And counsel for the state has filed an affidavit along with the report of the inspector in charge of so and so, wherein it has been mentioned that the victim girl has been rescued on so and so and was produced before the magistrate, where her statement under section 164 has been recorded, and the victim did not want to with her family members. She has been kept in Ashiana shelter home at Bhadrak for her safety and security. Documents are taken on record. Mr. Mahapatra and counsel for the petition submitted that he has received instruction that on 7/10/2023, in spite of the objection of the petitioner, the victim has been handed over to the family members of the accused. What is the age of the victim?
18 years.
At the time of his one year.
So, Bartaman kete kuhundu,
Now he's completed 18 years.
He seeks some time to file an affidavit to that effect as far as possible in course of this week. Please, this one. Yes.
No, affidavit file ready, but say as per the honorable learned JMFC 2 Bhadrak, my lord, the victim was allowed to stay with in-laws.
But during this period, she has completed the age of 18 years, and after that, she had married to her loving person in a temple by way of exchange of the garland. Wherever the victim was produced with so she has annoyed to go with her parents instead for the direction of the swan. So the victim girl was allowed to stay with her in-law, in which she is staying the investigation. So,
kindly see the statement 164 statement recorded. He has not started anything before the
order sheet re lekha hithibo na seti kai lekha hithibo
nani sir
164 se ghotana bishay re kahithibo
order sheet 164 re khali kahichi
kon padile se relevant portion
mu kichi 4 line mela bisho aji court re deochi ki bayan deochi ki mu mor mausi gare rahi paଠ पढुथली mausi गाली करियारु mu गत 29/4/2023 तारिख दिन घरु बाहरी पुन्ना जेना सहित मोर संग सहित विशाखापाटना पळिली गतकाली आसी थाना रे देखा करी जणाइली मते केही अपहरण करनांती
आज से भागर फागर
on that time
lord what happened
just a minute
marriage is that also the receipt of the mandir and the affidavit also
and apun ei jo katha ta lekhile bartaman
because they rescued and they also once it was recorded and medical
no so he is right Mr. Mahapatra is right they 164 re taro bahagar ko mandir re haba katha
bahagar mandir hota
bas ye taro ethikar jaingini rahiba katha ta swami au ta sasu gare ए विषय रे तार 164 स्टेटमेंट रे किछि
କିଛି
कहू
କହିଲା ନାହିଁ
तो आपण कोड पाइले जो जिंसडा आपण जो रिपोर्ट टा देले एटा
Madam.
कोड पाइले
2 affidavits and 1 Parvati Mandir victim and the accuser.
Subsequently, intentionally with the gloves of police.
wait एटा आपण की देलानी आयु को की देला
I देखियो कि देख में आनी but both of them and
आकु कन्फ्रंट करथिले विक्टिम को एगोडा जेन्युइन की नाही कारण 164 रे बाहागर कथा टोटल उठी
आरएसटी कोते पढिसले तापर रहितला
ठीक अछि जे हमें
सेठी-
कहया कथा जे आपण को सोर्स रे एभली डॉक्यूमेंट मिलिला विक्टिम तो ता सासु घरे रहउछि ना जदी
आगे।
आपण बाहागर हेइ जइथिबो
आगे
ताले आपण जाई पचारलेनी विक्टिम
कारण
को
ए
जे
बाहागरटा होची 3/10/2023 रे
हां
3/10
ए 164 केबे रेकॉर्ड हला
5 रे आगे
5
4 ना 5 रे
तुरंत 164 डेट टा के देखो
5 रे आगे
वेट
164 हला 4/10 में
4 ता माने बाहागर परे हेइ
पर एज बट ही हैज नॉट फैक्टेड
सो कोन वर्तमान आपण सेही ये बेसिस रे इंस्ट्रक्शन नियंतु
आगे
से जो एफिडेविट पाइचंती बा से जो मैरिज पाइचंती से विक्टिम को जाइकिनी कन्फ्रंट करंतु जे प्रकृत रे एमती किछि एफिडेविट हेइतिला कि नाही प्रकृत रे कोटा को मंदिर कोन से जो नीलकंठ ना कोन सेठी बाहागर हेइतिला कि नाही आउ से केमती रहउची सोइचार रहउची कि नाही भलर अछि ना नाही किंतु से विषय रे आपण जोटा लेखिले ता किछि ये नाही ना तार
ଗୋଟେ ମୋମେଣ୍ଟ ମିଲ ସେ 4 ରେ କଣ ହେଲା ଆମକୁ ଡାକିଲେ ନେଇକି 164 କଲେ ଦେଇକି ଆସିଆନ କୁ ଛାଡିଲେ ଯୋଉଟା ତାଙ୍କର 5 ତାରିଖ ରିପୋର୍ଟ
on 23/10/2023 again re-examine the victim girl matter
अच्छा
161 matter
हां
may place matter
हां पछो
ମୁଁ ଅର୍ପିତ ବିଶ୍ୱାଳ ଆଜି 23/10/2023 ତାରିଖରେ ଏଇ ମୌଖିକ ବୟାନ ଦେଉଅଛି କି ମୁଁ ଗୋଟେ ପୁଅକୁ ଭଲ ପାଉଥିଲି ତାଙ୍କ ସହିତ
23/10
ମାଇଲ
हां
ଆଫ୍ଟର ଦି 164
हां
ରାତିରେ ତାଙ୍କ ସହିତ ରାତିରେ କଥା ହୁଏ ମୁଁ ମୋର ମାଉସୀ ଘରେ ତୁଳସୀପୁରରେ ରହୁଥିଲି ମୋର ମାଉସୀ ପୁଅ ଭାଇ ସେଇ ପୁଅ ସହ କଥା ହେବା ସମୟରେ ସେ ଜାଣିପାରିଲେ ଯେ ମୁଁ ତାକୁ ଭଲ ପାଉଛି ବୋଲି ଜାଣିବା ପରେ ତାପରେ ସେ ମାଉସୀ ଘର ଲୋକ ସମସ୍ତଙ୍କୁ କହିଦେଲା ଓ ସେ ମତେ ବାହା ହବ ବୋଲି ବାଡାଇଲା ମୁଁ ସେଦିନ କିଛି ନ କହି ଚୁପ୍ ରହିଥିଲି ସେ ମଧ୍ୟ ଆମ ଘରକୁ ଫୋନ କରି ଜଣାଇଲା ପୁଣି 20/4/2023 ତାରିଖ ଦିନ ସନ୍ଧ୍ୟା 5ଟା ସନ୍ଧ୍ୟା ପ୍ରାୟ 9ଟା ସମୟରେ ବାଡାଇଥିଲା ସେଇ କଥାକୁ ନେଇ ତେଣୁ ମୁଁ ସମସ୍ତେ ମାଉସୀ ଘରେ ଶୋଇବା ପରେ ମୁଁ ରାତି 1ଟାରେ ଲୁଚି କାହାକୁ କିଛି ନ କହି ଘରୁ ପଳାଇଗଲି ମୁଁ ପରେ ମୋର ଗୋଟିଏ ଝିଅ ସାଙ୍ଗ କୁନୁକୁ ଫୋନ କଲି ଏବଂ ମୁଁ ଘର ଛାଡି ପଳାଇ ଆସିଲି ବୋଲି କହିଲି ସେ ମତେ ତାଙ୍କ ଘରକୁ ଡାକିଲା ମୁଁ ତାଙ୍କ ଘରେ ଯାଇ ସେଦିନ ରାତିରେ ରହିଲି ସେହି କୁନୁ ଜେନା ପୂର୍ବରୁ ବିଶାଖାପଟ୍ଟନମ ଚିଙ୍ଗୁଡି ଫାର୍ମରେ କାମ କରୁଥିଲା ଗତ 21/4/2023 ତାରିଖ ଦିନ ମୁଁ କୁନୁ ସହିତ ବିଶାଖାପଟ୍ଟନମ ଗଲି ଏବଂ ତା ସହ ମିଶି ସେଇ ଚିଙ୍ଗୁଡି ଫାର୍ମରେ କାମ କଲି ଏବଂ ସେଠାରେ ତା ସହିତ ରହିଲି ଗତ 27/9/2023 ତାରିଖରେ ମତେ 18 ବର୍ଷ ହୋଇଥିଲା ମୁଁ ଭଲ ପାଉଥିବା ପିଲା ଯାହାର ନାମ ଦୀପକ ପରିଡା ସେ ଓ ମତେ ବିଶାଖାପଟ୍ଟନମରୁ କୁନୁ ପାଖରୁ ଆଣି ଯାଜପୁରରେ ଷ୍ଟେସନରେ ଗତ 3/10ରେ ପହଞ୍ଚିଲା ସେଇଦିନ ଆମେ ପୁଅ ଘର ତରଫରୁ ପୁଅର ବାପା ସାନ ବାପା ଓ ଅନ୍ୟ କିଛି ସମ୍ପର୍କୀୟ ଉପସ୍ଥିତିରେ ଆମେ ଯାଜପୁର କୋର୍ଟରେ ବିବାହ କରିଥିଲୁ ଏହା ପରେ ଭଣ୍ଡାରୀ ପୋଖରୀ ଥାନା ଅଧିକାରୀ ଥିବା ହର ପାର୍ବତୀ ମନ୍ଦିରରେ ପୁଅର ବାପା ସାନ ବାପା ଓ ସମ୍ପର୍କୀୟଙ୍କ
उपस्थित विवाह करथिलु तापर गत 4-10 तारिख रे मोर स्वामी दीपक परिडा एवं मु आसी भंडारी पोखरी थाना रे हाजर होइथिलु या मोर सत्य बयान है तो
What happened, bro? 4 तारिख रे मु डाकिले तांका स्टेटमेंट रेकॉर्ड ही हैज नॉट स्टेटेड एनीथिंग
यो
फिफ्थ
बाहार नहीं ता स्वामी पाखे रहउची काई ता डिस्टर्ब
फॉर ए मोमेंट मिल 5 तारिख 6 तारिख रे अगेन डाकिले देके एशियन को पठैले ଏବଂ 7 तारिख रे हमको डाकी कि नाउ व्हाट हैपेंड मी लॉर्ड नाउ शी इज प्रेग्नेंट हमें तम कहलु मेडिकल एग्जाम टिल टुडे ही इज नॉट मुझ एग्जामिन जदी से प्रेग्नेंट अछि बिफोर माइनर दैट इज द केस ऑफ 376 मी लॉर्ड
for the petitioner and counsel for this
एंड माय सबमिट हचलो जे जेतेबेले से तार बाहागर कहूनी 5 तारिख रे ताको व्हाट बेसिस रे तार ऑपोजिट पार्टनर 3 घरु पठाउछंती
on the status report has been filed
so it
by
is a
the
160
SI of
statement below
Bhandari Police
development below
Station, from which it appears that the victim has completed 18 years of age and thereafter she married to her loving person in a temple by way of exchanging garland and then
I pray one thing, my lord. Let it say produce whether she is अच्छी कि नहीं तंग पकड़े जाए.
annoyed to go denied to go with her parents and therefore as per the order of the JMFC, London JMFC 2 Bhadrak, the victim was allowed to stay at her in-laws house in which she is now staying. The London Council for the state placed the 164 CRPC statement of the victim, which was recorded on 164 ta kebe recorded itla on 4/10/2023. And though the marriage is stated to have taken place on 3/10/2023 in a temple, but since the victim did not state about the said marriage in her 164 CRPC statement, and the London Council for the State produced the affidavit of the victim as well as the her husband, so also the
marriage receipt.
So also the receipt of marriage of the temple where the marriage is stated to have taken place. We ask the London Council for the state that from which source those documents were received by the investigating officer and whether the victim has stated anything about the marriage or not. The London Council for the state, after verification of the case record, submitted that another statement of the victim has been recorded on 23/10 on 23/10/2023, in which she has stated about her marriage with one Konta Nada Deepak
Parida. Copy number 3, my lord. Deepak Parida.
Deepak Parida. And she was staying in her in-laws house. In view of such statement of the victim and the documents produced by the Land Council for the state, no further order is required to be passed in this expedition, which is accordingly disposed of. Yes.
Item number 23.
Not yourself dispose of this.
Disposed of. नाती ହେଲା ପରେ କି ନାତୁଣୀ ହେଲା ପରେ ନେଇକି ଯିବେ 21 କରିବା ପାଇଁ. Yes, next.
Item 23.
Okay, tomorrow.
Item 24.
7, 11, 20, 24 years, Mr. Bhanjdev.
Let it be day after tomorrow because the two childs were rescued. It is out of the state, my lord. They are returning today, my lord. They will reach and they will be produced before the CWC, my lord, as per my lord direction. So they will produce tomorrow. So they reckon them day after tomorrow.
No, last time, of course, this order was there, no?
They say the rescue
Now,
now
both the children are rescued.
Okay. As per the instruction I received.
All right.
So we are just keeping it on this from this
Better
weekly
my
list.
lord Thursday because
Thursday, okay. From this weekly list it will be taken.
yes ma'am.
Oh. So it will डाकिबे आपण 9 तारीख दिन 9, 11, 20, 23. Yes.
Item 25.
I beg your lordship, pardon, my lord, your lordship may lordship kind attention 9th October order, the order of lordships, my lord. Paragraph 3 is very much important that they not test out.
Wait. Shrikant Kumar Pati, OIC, Pirahat Police Station, Bhadrak is present and he has filed a detailed report regarding the progress in the investigation, from which it appears that several probable places have been searched for tracing out the victim girl and the suspected person, and raid has been conducted, but the whereabouts of the victim and the suspected person is not known till now. The officer in charge submits that since he has joined his present place of posting 1 month back, may be given some further time for the purpose of rescuing the victim girl and tracing out the accused. Okay. कौन हला आपण करता पर
सर
कौन डेवलपमेंट हला कुहंतु
सर तापर हमें सर अदर डिस्ट्रिक्ट जोड़ा सर हम जाइजु केंद्रापड़ा जाइजु सर राजनगर जाइजु सर तार अकाउंट ता मार सर जोड़ा अछि पंजाब नेशनल बैंक रे ताको सर हमें आनी की सर देखलु सेटा गोटे एटीएम यूज हो सर जोड़ा केंद्रापड़ा हो डीसी बैंक रे सर से डीसी बैंक सर हमें प्रेयर करू सर से तार सीसी फुटेज मध्ये दैचंदी सेटा सर क्लियरली विजिबल हम गोटे डेट रे मागिलु सर जेहेतु 2/11 से हमको इश्यू कले तेणु हम सर टाइम बेसी पाइना सर वेरीफाई करिया पई जेहेतु से यूपीआई यूज करू एवं पेटीएम यूज करू सर हम सेंसर साइबर सेल को सर रिक्वेस्ट करछु सेटा को नंबर रे पेटीएम आ यूपीआई यूज होजी सर सेटा से हम जणे सर फर्दर
ता माने ए केंद्रापड़ा लोकालिटी रे दे आर अवेलेबल ना को
सर आई थिंक सो सर now तार मदर एंड फादर सर हमको जेहेतु कोऑपरेट करू ना नोटिस सर देथिल हमको अपियर करिया पई लास्ट 5/11 सर से
कहा बापा मा कोऑपरेट कोन
अक्यूज सर ता मदर कले जे मोर कोनसी अकाउंट नंबर नाही बट सी हैज अकाउंट नंबर ऑन पंजाब नेशनल बैंक तेणु ऑल अदर फैमिली मेंबर सर थाई पारे सर तेणु तंगा हमरे मोबाइल नंबर आउ आधार लिंक रे सर हम पाइल ना
एटीएम कार्ड टा रही छि से पिल्ला पाखरे
सर हम भाबु सर से पिल्ला यूज करछु सर
अच्छा
जेता मा मना कला मोर अकाउंट नाही एवं से अकाउंट रे एटीएम यूज होउजी सेनो फर्दर ताको सर क्वेश्चन करिया सर डाकी दिलु सर काली
नहीं सेथुर तो लोकेशन जणा पड़ जिवो ना
सर
को
अच्छी
पर्टिकुलर हां
सर एटा केंद्रापड़ा सर से यूज करछु सर जैसे केंद्रापड़ा यूज करछु गोटे सर हमें टाइमिंग सर मागितलु सर सीसी फुटेज सर
हां
से तो कैप पिन गोटे यंग आछी सर
अच्छा
तेणु तार फेस सर टोटली विजिबल सर हो नहीं फुल्ली तेणु अदर टाइम टा सर टिके टाइम लागो सर बैंक रु काढिया पई अन्य को टाइम रे सर से एटीएम यूज करछि सर पुणी सर फर्दर सर प्रेयर करिया पड़ियो हमको से डेट और टाइम रे सीसी फुटेज दिया जाउ सर तेणु जैसे यूपीआई एवं यूपीआई और पेटीएम यूज करू सर आम साइबर सेल सर प्रेयर करछु जे से पेटीएम यूज हेले होय तो तार सर टेलीफोन नंबर और फेसबुक की आउ जा सर मिलबा हम ताको फर्दर सर फॉलो करू
आपण मिस्टर दास मेरा ए जो एटीएम रे कैमरा जो पर्पस पई रखा है सेटा जदी ए टाइप रो कन्सील्ड फेस रे की आसिकिनी ताकू जदी विथड्रॉ करनबो ट्रांजैक्शन हबो कहार अन्य अकाउंट रो बा ताऊ एकू तला आपण किछि लाभ पाई परिबेनी पाई परिबे तेणु व्हाई नॉट द प्रोविजन इज मेड दैट अनलेस द फेस इज जदी टेक्निकली किछि हेई परियो पॉसिबल जहार फेस विजिबल हबनी बैंक ताकू सेमथी ताकू अलाउ करा जीवनी either proper instructions should be in that ATM itself or some kind of technology to that face को मध्य देखी कि नहीं ये it's not that X Y ATM card Y use करी परिबन एक करी परिबो जे जी भी करू but
his face should be
हाँ हाँ कारण बहुत समय रे यूज होची जे हम एटीएम कार्ड नहीं गले ये नहीं गले तापरे ताकू से देई कि नहीं काढी नेले टंका that identity ए विषय रे जस्ट हायर लेवल ले कथावार्ता करंतु जदी कि सेमती मेकानिज्म बाहरी परिबो
जे for this matter RBI has to give a
हां नहीं कहूची अपन लेवल ले ए जो प्रॉब्लम टा वर्तन फेस कले
understand
से टोपी पिनिन आसिला टोपीटा को हाइड आउट करिकिन बस नहीं पळेला जानि पारलेनी आइडेंटिटी
it is regarding the quality of CCTV. More sensitive camera can catch it. So it is now coming blur or distorting.
ଗୋଟେ ପୋଜିସନରେ ବୋଧେ ରହୁଥିବ
ଗୋଟେ ପୋଜିସନ ଫ୍ରଣ୍ଟ ରୁ ରଖନ୍ତି
ଦିଟା ଖଣ୍ଡେ ପୋଜିସନ ବା ସେଠି ଯୋଉ ଏଟିଏମ ରେ ଯଦି ଗାର୍ଡ ଥିବ
ଆଗରୁ ଗାର୍ଡ ଦଉଥିଲେ ଏବେ ଏତେ ଏଟିଏମ ହେଲାଣି they are not providing
But
that.
CCTV କେମିତି?
CCTV
ଗୋଟିଏ କ୍ୟାମେରା ପାଇଁ ସାର୍ ପ୍ରୋବ୍ଲେମ ହଉଛି, ସେଟା ବ୍ୟାକ୍ କରି ଯାଉଛି ସାର୍, ଯଦି ସେ ବୁଲି ପଡୁଛି ସାର୍, ସେଥିରେ ସାର୍ ଆଉ କ୍ୟାମେରା ତା ଫ୍ରଣ୍ଟ ରେ ଆସୁନି, ଲାଇଟନିଂ ହଉନି ସାର୍। ତେଣୁ ଯେତେବେଳେ ସେ କ୍ୟାମେରା ତା ଫ୍ରଣ୍ଟ ରେ ପଡୁଛି ସେତେବେଳେ ସେଟା ଟୋପି ପିନ୍ଧି ଏଟିଏମ କାଢିଲା ସାର୍, ସେ ମୁଭ୍ କରୁଛି।
there is a ଗୋଟେ 360 ଡିଗ୍ରୀ ର ନବାର ଗୋଟେ ଇଏ
କ୍ୟାମେରା ରହୁଛି
ସେମାନେ ନେଇଯିବେ, ଯେମିତି ଆମର ଏଇ ଯୋଉ ମୋବାଇଲରେ ମଧ୍ୟ ସେ ସିଷ୍ଟମ ଅଛି। ସୋ ଏଇଟାକୁ ଧରିଲେ ସିଏ ତ ଅଟୋମେଟିକ ବୁଲେଇ ବୁଲେଇ ଫଟୋ ନେଇଯିବ, ଗୋଟେ ଇଏରେ ବାହାର କରିଦଉଛି। ତ ସେଇ ମଧ୍ୟ ରହିଛି। ତ ସେଇଟାକୁ ଇଏ କଲେ ପ୍ରୋବ୍ଲେମ ହୁଏତ କିଛି ମାତ୍ରାରେ ଇଏ ଥିବ।
ଲାଇଟ ରେ ଗୋଟେ ଅବଜର୍ଭେସନ ଏଣ୍ଡ ଡାଇରେକ୍ସନ ରହିଲେ ବି ଆମେ ତାକୁ we can pursue the matter.
Yeah, you can say that you can find out the way and means.
Exactly. Because on this case particularly, it has happened, my lord. So on that basis, my lord can.
এই কেসরে সে আউজি না এই কেসরে
The officer in charge wants for Pirahat police station. Bhadrak is present and he has produced a detailed report regarding progress of investigation as per the order dated 9/10/2023. During course of interaction with the investigating officer, it has come to light that even though the mother of the accused stated before him that she is having no ATM card, but it came to light that her ATM card is used for withdrawal of the money, and that too within Kendrapada district area in different ATM counters, right? ATMs. Kendrapada area bhitar to
ଗୋଟେ sir DCB bank
once. However, he submitted that when instruction was sought for to furnish the identity of the person who has withdrawn the money from the said ATM, it came to light that a person wearing a cap almost covering his face came and using the ATM card withdraw the money, and the IO submitted that the identity of the person could not be ascertained due to such reason. We find that in many cases, the persons are withdrawing money, keeping their identity in secret by covering their faces or by adopting some other method. And if proper steps are taken by the bank authority to ensure the identity of the person withdrawing the money and that it is recorded properly in the CC camera, which is installed in the ATM for such purpose, it would be benefit not only to detect the person's identity, but in many cases to detect the crime if committed in case of illegal withdrawal of the money by using the ATM cards. The London Council for the State submitted that he will he will apprise the authorities of the state to have a talk with the bank authorities and particularly the RBI to issue guidelines in that respect for its implementation as soon as possible. After going through the status report, since the investigating officer is seeking for further time to trace out the victim girl and for rescuing the victim girl and tracing out the accused, we allow the time and the case is posted to 4th of December 2023. On that day, the so-and-so shall remain present with the up-to-date status report. This is taken on board.
May I pay, Manoj?
Yeah.
Because the Kali Puja is there, they want some more time in that area.
Acha,
So
acha.
for 15 days, they will order.
11th? All right. Keep it on 11th of. Yes.
Lordship,
ସେମାନେ ପ୍ରଚେଷ୍ଟା କରୁଛନ୍ତି, ଅପେକ୍ଷା କରନ୍ତୁ, ଧୈର୍ଯ୍ୟ ଧରନ୍ତୁ. Yes, next.
Item 26.
See the last order.
Last order is dated 3/10/23 or thereafter any order was passed.
No, that is the last.
So and so has been filed by the petitioner, so and so for direction, so and so minor daughter is 17 years, committed kidnapping and minor. The report was lodged. No sincere attendance, so notice on constant accepts notice on behalf of his. A detailed affidavit regarding steps taken shall be filed by the investigating officer. The case by the next date, giving copy of the same to the land. Affidavit file करेगी.
Last time after is man. I would have it ready with file.
तांको copy ଦେଇଛନ୍ତି?
No.
Copy उड़े दियंतु.
Affidavit ପରେ ଆଜି ସେଟା କା ମଜି ଉଠି ନଥିଲା affidavit ପରେ ପୁଣି again we have filed present status.
हाँ. I have examined the informant so and so. She is the original birth certificate. 21/1/2006. तामाने 17 वर्ष 9 मास 10 मास खंडे 9 मास. All right. Occurrence of kidnapping and so you're 17 years 6 months. Okay. On the date of occurrence, I'm getting info relevant so and so. Across the house. Getting information from reliable. I've conducted the raid in the house of friends such as so and so. Conducted raid of the house and is working near Tata Steel Ocean Company with the help of such as the workers of Tata Steel. They had no knowledge about the matter, no clue obtained but the rescue of the victim girl. So I contacted Sondro. Conducted search in the house of did not find him. Conducted so and so. And the accused had returned again to the working place and conducted raid and search the showing photographs on the zone. Identified them. I have repeatedly so and so. Race CDR analysis, source deployment, technology analysis. Persuasion. ओहो आगुरु दिथर से जाइथला त सेने दिथर लिखा है and rescued also love relationship discussion also accused seduced and so तो ये आउ बस आउ केते मास रहिला तार कंप्लीट हवा ପାଇଁ 17 वर्ष 9 मास ହେଇଗଲାଣି तो आउ 3 मास परे ହେଇଗଲେ ଆଉ କିଛି ଅସୁବିଧା ନାହିଁ as it appears
minor has been taken away.
it's all right technically offense question होची बर्तन रेस्क्यू जो ये ସେମାନେ ଥରେ 18 ହେଇଗला ମାନେ ବାହାରି ଆସିବେ ନା ତାଙ୍କର येरू आउ तापरे मैरिज
So IAC is supporting to the accused persons.
why
After
supporting
filing of the writ application, the IA has gone to the spot. That is the affidavit is
no,
till
now
28/7 they have taken
so
step.
many things he had done she has narrated what she has done from time to time what is the favoring ଜିନିଷ ଆପଣଙ୍କର ଝିଅ ଦୁଇ ଥର ଗଲାଣି ଏଟା ହଉଛି
I have mentioned after
ତାଙ୍କ ଇନଭେଷ୍ଟିଗେସନ ଠିକ ଅଛି ଆପଣ ଝିଅ ଦରକାର ତ ଟିକେ ଅପେକ୍ଷା କରି ଯାଆନ୍ତୁ ସେ ସମୟ ହେଇଗଲେ ସେ ଆସିଯିବ ସେ
କିଛି ନଥିବ
ଆଉ ବର୍ତ୍ତମାନ ତ ଏଟା ତୃତୀୟ ଥର ପାଇଁ ଏଟା ଆପଣଙ୍କର
ଏଟା second time. I have mentioned in the FIR 22/3/2023 after filing the FIR they have rescued
they have tried their level best all kind of we do not find at least any kind of irregularities
last attempt was taken on 28/7/2023 in paragraphs 8
who told you
there affidavit they mentioned
अरे affidavit ଆଜି ର ଏଟା ଦେଉନାହାନ୍ତି ତ ସେଟା ଦିଅନ୍ତୁ ହଁ 1/11 ପର୍ଯ୍ୟନ୍ତ ଯାହା ଯାହା ସେ କରିଚାଲି ଆସିଛନ୍ତି ସବୁଟା ଡିଟେଲ ମେନସନ ହେଇଛି ଆ ଦେହରେ ହଁ ସେଇଟା ଦେଖନ୍ତୁ ସେଇଟା ଗୋଟେ କପି ହ୍ୟାଣ୍ଡ ଓଭର କରିଦଉଛନ୍ତି ସେଇଟାକୁ ଆଉ କିଛି ଦିନ ପାସ୍ କରିଦିଅ ଏତିକି ଏଟା ତିନି ମାସ the Susmita Parida, Sub-Inspector of Police, Nursing Police Station, has filed an affidavit as per the order dated 3/10/2023, which is taken on record. The London Council for the State has also filed the status report of Nursingpur case number 97 of 2023, in which various steps taken by the investigating officer for rescue of the victim girl and to trace out the accused has been highlighted, which covers up to 1/11/2023. It is mentioned therein that as per the date of birth of the victim, and this is now 17 years 9 months, and twice the victim has eloped with the accused and was rescued. Considering the submission made by the London Council for the respective parties and hearing the perusing the report furnished and hearing the London Council, the investigating officer, we are inclined to grant some further time for tracing out the victim and also to apprehend the accused, so and so. Put up this matter in the second week of January 2024.
December
no, just to give say upon a period of various. Yes. Number 26 gala na.
127.
Sorry.
Last occasion, Lordship directed my London friend to obtain the custody certificate and to file their response.
Kaun eta?
My Lord, matter of
is it coming for the first time?
No, my Lord, second time. Your Lordship's order may kindly page 9/10/2023.
Representation filed by representation seeking to pass the proceeding of this also review board meeting and annexure 5 rejecting the case of premature release on the ground that due to young age he has not lost his potential for committing the crime is also. What is the custody certificate indicate?
I have obtained the custody certificate as well as the gazette notification, my lord.
Hmm.
But your lordship kindly have glanced to page 16 annexure A, your lordship. Column 13, my lord. Adverse report of the district authority. That is why it was rejected, my lord. Basing on that, that report has not come.
Well, he is challenging that.
Yes,
You
that
have
report.
illegally rejected my where have you already passed. So he has a right to know that what kind of adverse report he is challenging that.
That report is a must.
So you
Yes, your
furnish what is that report? Let us
Yes,
see.
madam. That is why I asked for some more time, my lord.
And what is the procedure laid down that is to be furnished? How far you have acted in accordance with that procedure?
Yes,
That is to be also furnished. And only ground, as you have pointed out in that that the adverse report. So we want to know that what sort of adverse report has been furnished.
As per that gazette notification, my lord, so eligibility of premature release, one of the condition is that where the convict has lost his potential for committing crime, considering his overall conduct in jail during the 14 years incarceration.
And that is also one of the criteria, but adverse report is what?
On the key adverse report.
Yes.
Jail le to rahithila na
So
se
that
period
report
re.
has not come.
Ah.
my lord.
And accordingly, you prepare your counter affidavit if you because it is to be finally heard and
Yes, sir.
decided. If you find that it has been illegally rejected,
Yes, sir.
so we can ask for fresh consideration in accordance
sir.
with law. So just file your
For that purpose, I need
the-
to file the response.
My lord, one thing, my lord.
yes.
That adverse remark with respect to the year 2020.
आसु आगे कौन से
Previous, na
कारण
present.
आपण तो 14 years ऊपर निश्चय थिबे बोधे
21.
20 years
More than 20.
तेणु ये जो रिपोर्ट गुड़ाक हाँ ये रिपोर्ट गुड़ाक केबेकार रिपोर्ट आपनकर जेल भीतर रिपोर्ट कंडक्ट कि नाही वो टाइप रो लेट हिम ब्रिंग इट लेखन the London Council for the State seeks some time after pointing out that annexure 3 regarding the reason for rejection of about the premature release by the State Sentence Review Board pointed out from annexure A to annexure A, it is at page 16, that on account of adverse report of the district authorities, the petitioner case prayer was rejected. However, he seeks some time to produce the adverse report and also file a counter affidavit by the next date, giving copy thereof to the Land and Council. He however submit that he has received the custody certificate.
Yes, sir.
Okay.
That
As
is
per the
18 years.
as per the order dated so and so, he has Quebecer order is la
No, thus.
9/10/2023.
Yes.
He has received the custody certificate, which
As well as
indicates
the
that
gazette notification.
the as well as the gazette notification, and it indicates that as on so and so date,
As on 19/10/2023.
as on 19/10/2023,
Yes.
the
18 years, 9 months,
petitioner had already undergone 18 years,
9 months,
9 months
7 days.
and 7 days. এটা উপরে রাখি দেবে তারপরে গুড়া করে লিখে দেবে তার ଗୋଟେ কপি ফাইল করে দো নাতি হ্যাঁ দি তার ଗୋଟେ কপি মধ্যে দেই দাও না টেকন অন ডেট তাহলে
First week of this.
ফার্স্ট উইক ডিসেম্বর 4 তারিখ 4th December 2020. So rest of the matters are hearing matters. So we'll take up tomorrow.
My lord.
My lord, ये जो order ता देखले 8 वर्ष में কথা কইলে That is not the present rejection.
No, let them bring.
Let
we'll
them
see.
bring up कौन अच्छी
That
तादेरे
means whether
देखें
they have
कहीं
a-
item 28, I reckon day after tomorrow, my
हम्म
28, the first hearing matter, my
तेरा बड़ा पार्ट है इतना
I think हम काले 9th बुधवार को
ये हाँ आउट का था मिस्टर दास ये जो एटा एक 28 नंबर टा से कहउछंती पहर दिन करिवे बाकी जो काउंसिल मानकर देखछन एरा मोस्ट ऑफ देम आर रेगुलर प्रैक्टिशनर्स तो तांकु कुहंतु somebody should at least 2 of them should remain present each day हला get ready and you also accordingly get ready कारण ये जो absence रे नचे से तो पुनी engage करिया पड़िबो जे ये अपन से अनुଯାयी most of the council are regular practitioners हला
May I please your lordship? Lordship, item number 35.
Yes.
Lordship, Lordship, I have filed a new Okalatnama. Previously, my name was there, but my name was shortly printed in.
There is no problem. You come to argue the case. It will be taken up tomorrow. Get ready.
Lordship.
My lord, jail criminal appeal number 2022. In this case, out of 10 years, has been in custody for more than 5 years.
Kind of matter.
Yeah.
My lord, lordships, package was on list. Tied up bail matter or list got you.
May I make a mention, my lord?
Matter from the list. Since your lordship is going to take up the election matters.
No, that may be for some time. So it's not that for the entire day. I'll take up the matter. As soon as
Item 148 and 230. 230, the interim bail period is expiring day after tomorrow. And 148 is her mother-in-law is on death bed. So may I pray?
We'll see. Ask the state council to bring those files. We can take up this matter. Yes.
My lord, item 124, 2 days weekly list. This matter for listed for orders, for modification of orders. My lord's granted bail on 16/10/2023. Granted bail to the appellate. One mistake, typographical mistake is there, my lord. The IA number has not been mentioned in this.
In which?
Item number 124.
124.
I have filed an IA in this case for a modification of the order.
But mention any. Acha, you 16/10/2023.
16/10/2023.
Okay.
Only IA number 2143 of 2023 has not been mentioned in this order.
All right. Signature ने नाली पेन ने मुद्दे दियो मुझे आया नंबर टा मेंशन कर दिया फाइल टा काढ़ी न थी all right तो ये करा कर दे
Item 117, my lord, there is 3-year conviction. He is on bail. Item 117, 117.
117 number.
117, my lord.
Yes.
Kindly taken up by tomorrow. Otherwise, 11 ko tara sarijibo 1 month.
Just there are some defect pointed out by the stamp reporter.
Grounds not mentioned. Gote habo a gote certificate of ta diya jaine boli gote.
You have given the copy to the state council.
My lord.
What is the conviction and what is the sentence?
Conviction is for 3 years, my lord.
It's a designated court under OPID Act.
My
Means
lord.
Mr. Bhuiya and Mr. Patra is to be.
OPID रे मु convicted है नहीं मु convicted है ची 420 and 419 रे 3 years पाई है ची 456 price cheat money circulation act that run to concurrently.
But it's all right. But I think he has to do with this matter.
I will provide a copy also to him.
Provide so that it can be taken up tomorrow.
My lord.
May pardon, my lord. Item number 142, my lord. On the last 2 occasions, my lord, we have mentioned this matter and Lordship has directed the state to produce the report, my lord. As the appellant is suffering from cancer, she needs urgent medical attention.
Yes.
PLAPL 7935, offense under 399402, long period of custody. My lord may take it up.
Which item?
My lord, it's not in the list.
Okay. File the memo.
I'm giving it.
Lordship, I am sorry. I am Akshay Biswal Lodi. Sir, my lords, I am on
50?
Lordship, I am sorry. Lord.
There is already an order that notice has to be issued and you have to serve an extra copy. Today you are serving. All right, the learned counsel for the petitioner serve the extra copy of the appeal memo along with the annexures on the learned counsel for the state today in court as per the order dated 10/10/2023. Let the learned counsel for the state comply the order dated 10/10/2023 and produce the written proof regarding service of notice on the informant as well as the case diary and instruction about the criminal antecedent. Put up this matter on 20th of November 2023. Yes.
So out of list, interim bail is expiring tomorrow. File extension for
give in number. Give that number to. Yes.
Out of list. Out of list.
Yes.
Milord,
And the face matter for bail.
Milord, CRLA number 203 of 2018. Milord, conviction is under section 376D of the IPC. Milord, 9 years he has already been in custody. And
file the memo. File.
Lordship, application criminal appeal for fair admission.
Give it, it will come.
Another memo tired of bail matter.
Lordship, against conviction, your lordship. One criminal appeal and tied up.
Give it.
Lordship, item 107, my lord. And the petitioner already convicted 10 years and 6 years plus also already.
Yes, all right, but when the matter reaches, I can take up. Please wait up.
Yes. Tomorrow, my lord.
All right, only see that. Yes.
My lord. CRL number 479 2020, my lord. Last time 16/10/2023 date hitla. Number as not number as
file the memo, it will come next week. File the memo.
Pardon, Lordship. Item 96, your lordship. Interim application of condonation of delay, your lordship.
96. What is this criminal appeal for?
Against conviction, your lordship.
What is the sentence imposed?
10 years, lordship, in offense under section 20B2C of NDPS Act, lordship.
And what is the delay pointed out by this SR?
Lordship, 2098 days.
2000?
Yes, lordship.
So you file a objection. IA number so and so. This is an application for condonation of delay. The stamp reporter has pointed out that there is delay of 1978 days in filing the criminal appeal. Land counsel for the state seeks some time to file the objection to the delay condonation application. Put up this matter in the week commencing from 4th of December 2023. Objection, if any, to the delay condonation application be filed in the meantime, giving copy to the land counsel for the appellant. Yes, next.
My lord, item number 204, CRLA 861 of 2023. My lord, on the last occasion, the learned state counsel was directed to obtain instruction on the marital status of the victim.
Okay. Count kete number coaching the file tamagi the count. Yes.
PLAPL 674/22. Before vacation, that list with that
File the memo.
5692, but
Let's tied up
taken up supplementary list.
File the memo.
tied up matter, my lord.
Give it.
Orders are delay, 10 days delay.
Which matter?
215 lordships.
15 the work. Case of conviction.
Yes, my lord.
What is the sentence imposed?
20 years lordships.
Huh?
20 years.
20 years. Delay is 10 days. Yes, Mr. Das, delay is 10 days in filing the claim. IN number so and so. This is an application for condonation of delay. The stamp reporter has pointed out that is delay in 10 days in filing the criminal appeal. Since it's a criminal appeal is against conviction and the sentence imposed is 20 years. After hearing the land council for both the parties and going through the arguments taken in the interim application, I'm trying to condone the delay. Accordingly, delay is condoned. IA disposed of hard admit call for the trial court record. You have not filed any application for bail, etc.
No,
All right. That's it.
Please stay
My lord, item 142.
Stay will be considered. What is that number he said? What is the number, Mr. Counsel? 215.
215 lordships.
Yes.
Item 142, my lord. And I filed a application for extension of bail, and your lordship directed the learning council for the government to take instruction, and it could not be listed. May I pray it can be taken up tomorrow, my lord?
What is the item?
Item 142. Sub item CRLA 641. And person is an old person, he cannot move, my lord. He has already remained more than 8 years out of 14 years.
Say modification of the order dated.
Extension, my lord. I am the sub item CRLA 641.
Oh, I see. Extension of interim bail.
My lord. Old person, he cannot move, my lord. 8 years
We'll
remain.
see that. We'll see it tomorrow. Yes.
My lord. Okay.
My lord, item number 140. The government had to give the verification report, my lord. Already 7 years in the imprisonment. Punishment is 10 years, my lord.
Okay. In the matter reaches, we can take up. Please wait.
140. Okay.
Yes.
Criminal revision 570/23. Juvenile of 14 years is in custody since 4 months.
What is the number?
Item number, it is listed on 1011 list, item 299.
1011.
Yes, ma'am. On 1011.
Why are you mentioning today? Today we are on 6th list. So when 10th will come, that you mention on that day. Okay. Yeah. Yes, Mr. Mishra.
Mr. Mishra was supposed to address your lordship as to the right to begin. Who should begin, the defendant or the plaintiff? We had cited order 18 rule 1. It should be 18 rule 2. But let Mr. Mishra apprise your lordship. Then we have got judgments. Order 18 rule 2.
In the that GRCO civil, there is a about the argument. It is stated that it should continue from day to day.
Yes, my lords. Yes, my lords.
So
and my lords, order 18 rule 2. Your lordships may kindly see order 18 rule 2.
Lordship, I am sorry. I have to mention.
Please. Yes, order 18
rule 2.
Yes.
Order 18 rule 2. 1. On the date fixed for the hearing of the suit or any other day to which the hearing is adjourned, the party having the right to begin shall state his case and produce his evidence in support of the issues which he is bound to prove. That we have already done. Thereafter, the other party then shall state his case and produce his evidence, if any, and may then address the court generally on the whole case. The party beginning may then reply generally on the whole case. So, my lords, he closes, I start my case, I prove my case.
Those stays are over already.
No, my lords, this is
the other party shall then state his case and produce his evidence. He has already produced his evidence.
Produced my evidence and closed my case.
No. You have produced so far as applicability of sub-rule 1 is concerned.
Yes, my lords.
That is rule 2, that is applicable to you. And so
Yes.
far as rule 2 is concerned, that is applicable to Mr. Mishra's client.
Mishra's client.
Right.
Responded.
The party beginning then reply generally on the whole case. Correct?
No. Your lordships may kindly take up order to
You
rule
come
2
to
again.
3A. 3A may be
The other
relevant.
party, two my lords. The other party shall then state his case.
That means Mr. Mishra.
Yes.
Yeah.
And produce his evidence, if any, and may then address the court generally on the generally on the whole case. So he is to argue and explain to your lordship the entire case. Thereafter, the party beginning may then reply generally on the whole case. So, my lords, there are judgments, judicial
Any
pronouncements.
party may address oral arguments in a case and shall, before he concludes the oral argument, it may submit, if the court so permits, concisely and under distinct heading, written arguments in support of his case to the court, and such arguments shall form the part of the record.
Yes.
Copy of the written argument shall be simultaneously furnished to the opposite party. No adjournment shall be granted for the purpose of filing written argument unless the court, for reasons to be recorded in, consider is to be so and so. Court shall fix time limits for oral arguments by their party. I have already stated that even if you begin and he replies thereafter, there is nothing which prohibits you from giving reply to Mr. Mishra's.
My lords, why we are harping on this issue, my lords?
Yes.
Because if there is a procedural irregularity, my lords, it may lead to setting aside of the entire judgment. That is, my lords, if your lordship sees, this is the judgment of the Orissa High Court first, a division bench judgment, my lords, wherein they have discussed Order 18, Rule 1 and 2. Para 7, your lordships may kindly see, my lord.
Yeah.
The procedure to be adopted at a trial is laid down in Order 18, Rule 1 of the CPC, which says that the plaintiff has the right to begin unless the defendant admits the facts alleged by the plaintiff and contends that either in point of law or on some other additional facts alleged by the defendant, the plaintiff is not entitled to any part of the relief which he seeks, in which case the defendant has the right to begin. Rule 2 of Order 18 says that the party having the right to begin shall state his case and produce evidence in support of the issues which he is bound to prove. Now, my lords, thereafter, paragraph 11. The true rule in such cases is laid down in Amir Ali's commentary on this bunch of sections to the following effect. When the issue raised by the court is in substance whether the plaintiff's or defendant's story is true, it is possible that neither of the stories may be true. The question then arises which of the two alternative issues is the true material one. So the really material one is the first of the issues. Is the plaintiff's story true? If this rule is applied as the proper test to the facts of the present case, the court has before it two alternative stories. Firstly, that the plaintiff had a reputation which has been damaged, giving him a right that this is peculiar to that case to recover damages, and as against the defendant claims privilege, fair comment and justification by truth. Neither of these versions may ultimately be found to be true. In such a situation, it would clearly be the duty of the plaintiff to prove in the first instance that his story is true. Now your lordships may see the relevant paragraph 14. Paragraph 14.
Yes.
It should therefore be borne in mind that the right to begin is not the same as the adducing of evidence in support of a party's case. There is a distinction between the two. It is open to the plaintiff to say that although he has the right to begin, he may rest content with relying upon the averments made in the written statement and may say that he does not propose to adduce further evidence. But the plaintiff should make the statement before the defendant is called upon to adduce evidence. Unfortunately, the court below has confused the entire issue and has called upon the defendant to open his case even before the plaintiff went into the box or testified to the truth of his story. We are clearly of opinion that the order of the learned subordinate judge is erroneous and must be set aside. The
Those
second,
stages are, Mr.
those
Anbu,
stages are over.
over.
Now
Now,
paragraph
if you,
15.
your judgment, which you are placing, if paragraph 12 is taken into account,
Yes, ma'am.
then the first thing it has been stated in the previous paragraph. So the real material one is the first of the issues. Is the plaintiff story is true?
Yes, sir.
Then paragraph 12 last sentence, in such a situation it would be clearly be the duty of the plaintiff to prove in the first instance that his story is true. So you have adduced evidence, he has adduced evidence. Now you are to prove that your averments taken are true, and I have adduced this oral evidence, this documentary evidence, so my case is true. Then he has to give the reply.
No, I'm coming to that, my lords. Your lordships may see paragraph 15. The second point urged before us is about the maintainability of this revision. It has been contended that however erroneous the view taken by the court below may be, it does not affect its jurisdiction, nor does it constitute a material irregularity in procedure. We are unable to accede to this contention, as we are of the opinion that if there is a clear breach of the provisions of rules 1 and 2 of order 18 CPC, as well as the rules of evidence, if we do not interfere at this stage, it may well be that the point will again be agitated at a later stage, necessitating an order for retrial. Such a course would involve the parties in considerable expense. So,
No,
we are citing.
they are what has happened. You see what stage they had come. They had come when the issues were framed. Please
Yes.
come to paragraph number. So issues were framed. Then the question arose as to who has the right to begin.
Yes, well.
At that stage, they have come,
But-
and they say that if you want, ordinarily it is to plaintiff who has to begin the case as per 18(1). If it is not, then the other side is to. That is, they have said that if this procedure is not followed, it may be an illegality. But we have already crossed that stage.
No, my lord, I am only citing this judgment for the purpose of apprising your lordship that if there is a procedural irregularity insofar as order 18 rule 2 is concerned, then there is a chance that the entire judgment may be vitiated. That is why.
18.2 nowhere states about this stage. 18.2 says that on the date fixed for hearing on the suit or any other day to which the hearing is adjourned, the party having a right to begin shall state his case and produce his evidence
Yes.
in support of the issues. Then the other party shall state his case and
Yes.
produce his evidence. Those stage has already been over.
And may
case.
then address the court. Then what happens to
May,
after he closes his evidence? Then he
Yeah.
will address your lordship about
then,
his entire case.
then a separate section or sub-rule has been provided
Yes.
that then the any party may address oral arguments in a case.
Beginning.
The party beginning may then reply generally on the whole case.
On the whole
Any
case.
any
First,
party
he will
may address
speak
oral.
about the whole case,
Just
and then
any
I will
party may
speak.
address oral arguments in a case and shall before so and so. Okay, what is your reply, Mr. Mishra, to this particular?
We are citing all the judgments so that Mr. Mishra
Yes.
can give a comprehensive reply.
You come straight to Mr. Mishra, this order 18. Yeah.
Then paragraph, I'm citing another.
Another
judgment.
decision.
We have 3 judgments we are citing. Because, my lords, there are your lordships have to give a judgment on this issue. If your lordship holds that we are to start, we will start immediately. And if your lordship holds as the defendant has to start, then they have to start. My lords, paragraph 8. This is the 3rd page, my lords. Eta hala Calcutta High Court, in the High Court of Calcutta, Turner, Morrison and Company Limited versus Hungerford Investment Trust Limited. Suit number 2005 of 1960. Manupatra citation. Manu stroke WB stroke 0406 stroke 1960. Malas, I'm drawing your attention, your lordship's attention to paragraph 8. At the end of the evidence, Malas, a point was raised about the right to begin. Malas, this is the stage. End of the evidence. Mr. Sankardas Banerjee for the plaintiff
Yes.
submitted that as the defendant had not called any witness and has not given oral evidence, but has exhibited documentary evidence, the defendant should begin. He relied on a practice note printed in the case of Welter versus. The practice note as reported is hardly on the point. There was a case which apparently was only concerned with the amount of damages because there the defendant had admitted liability. In cross-examination of the plaintiff's witness in that case, certain documents of account of the business not adduced in evidence on behalf of the plaintiff were put. Your lordships may skip all this. Then your lordships may come to 6th, 7th line. The relevant provision is contained. Lordship gets it? The relevant provision is contained in our Order 18 Rule 2 of the Civil Procedure Code. It provides that the party having the right to begin shall state his case and produce his evidence in support of the issues which he is bound to prove. The other party shall then state his case and produce his evidence, if any, and may then address the court. Your lordship, may again I'm reiterating, the other party shall then state his case and produce his evidence, if any, and may then address the court generally on the whole case. Finally, the party beginning, that is the plaintiff, may then reply generally on the whole case. The expression his evidence in Order 18 Rule 2 does not state whether it is oral or documentary, and if evidence means, as it normally should, both oral and documentary evidence, the party producing documentary evidence, even though by way of cross-examination and making an exhibit on his behalf, may be said to be producing his evidence within the meaning of Order 18 Rule 2. Mr. Mukherjee for the defendant submitted that on the facts also this case was different from the practice note in such and such All England Reporter. He points out that in the documents which were annexed to the defendant's petition, and therefore there was really even no special documentary evidence adduced at the trial through the plaintiff's witnesses. It will be, however, not necessary to pursue this point any further. Apart from the special fact, I would say that the expression his evidence in Section 136 of the Evidence Act would include any evidence given either through witnesses and oral evidence called on behalf of the party giving it, or even through cross-examination of the other party's witnesses and exhibiting them on behalf of the party who put such case in cross-examination and get such document proved through a cross-examination of the other party's witnesses. On that basis, Mr. S. Mukherjee, who appears for the defendant, must therefore have to argue first for the defendant. I therefore hold on this point in favor of Mr. Sankardas Banerjee for the plaintiff and order that S. Mukherjee for the defendant would begin his arguments. There the case was, they said that as we have not adduced any oral evidence, so the plaintiff should begin first. The Honorable Court said that no, once you have adduced documentary evidence also, documents also, that is in the nature of evidence, so you have to begin first as per Order 18 Rule 2. So this is, and this I'm citing Etahalai. Yeah. Aguda Dochi again, Bombay High Court.
Yes.
Para 2 months. As the plaintiffs to suit 432 of 67 had exercised the option under Order 18 Rule 3 of the Code of Civil Procedure of reserving the evidence on the issues on which burden of proof was on the government, the question was as to the order in which the learned counsel would address the court would have to be decided in reference to the provisions of the said rule. Before I go to that rule, however, I may refer to Order 18 Rule 2 of the said court, which lays down the general rule that when evidence on both sides has concluded, the party other than the one which had the right to begin must address the court generally on the whole case. It further provides that the party beginning may then reply generally on the whole case. A careful reading of Order 18 Rule 2 shows two things. First, that it makes a distinction between an address and a reply to that address, and secondly, that it proceeds on the principle that the party which has unfolded its evidence first must have the last word in addressing the court. I have unfolded my evidence first, so I shall have the last word as per Order 18 Rule 2 to address this honorable court. In addressing the court, curiously enough, Order 18 Rule 3 with which the court is concerned in the present case does not use the term address at all, but deals only with the reply, which is to be given to the evidence produced by the defendant on the issues in regard to which the onus is on the defendant, as well as the general reply to the whole case. SETI, then they directed paragraph 4, first, that is at paragraph 4, my lords. The defendant's counsel to address first. They've given the sequence who will address whom first. Mr. Shambhu on behalf of 6th defendant, C.J. Shah on behalf of the government, G.A. Thakur on behalf of the clearance contractors firm, which is the plaintiff, who's the plaintiff, and Mr. C.J. Shah will reply at the end only to the addresses by Thakur on the evidence. This is one. And my lords, I'm giving another judgment. Para 93 of this judgment, 2012 to SCC. At page 196, Rasiklal Manikchand Dhariwal versus MS Food.
Page 100 कितने? 2007.
12 to SCC.
2000.
से भूल दे दी चंदी बता. Your lordships may see this. They say that the code of civil procedure has to be adhered to. Both the parties must adhere to the code of civil procedure. The paragraph 92. Only one para. This is on the for the my lords that both the parties have to adhere to the code of civil procedure.
Yes, Mr.
Case under the provisions of the representation of people such I invite your lordship's kind attention to section 87.
Appear to. Eighty-seven.
Subsection 1. Your lordship, subject to the provisions of this act and of any rules made thereon, every election petition shall be tried by the High Court as nearly as may be in accordance with the procedure applicable under the Code of Civil Procedure 1908 to the trial of this. This is the first requirement. Kindly come to subsection 8. The provisions of the Indian Evidence Act 1872 shall, subject to the provisions of this Act, be deemed to apply in all respect. I lay emphasis on all respect to the trial of the election. So while your lordship is deciding an election application, it has to run on two wheels. One, Code of Civil Procedure, as nearly as may be put. Second, entire application to the Indian evidence. Now I invite your Lordship's kind attention to the Civil Procedure Code, Order 18. Already, Order 18 has been placed by my friend before your Lordship. Right to begin. The plaintiff has the right to begin. Unless the defendant admits, I leave the rest part. Then, Rule 2, statement and production of evidence. On the day fixed for the hearing of the suit or any other day to which the hearing is adjourned, the party having the right to begin shall state his case and produce his evidence. As your Lordship rightly observed, that this situation has already gone. They admitted that they have the right to begin, and accordingly they produced their evidences and evidence first. Next comes sub-rule 2. The other party shall then state his case and produce his evidence. I have also state my case and I have made it. So the evidence stage is gone. Now comes the controversy comes. Which party to address the Honorable Court? Kindly look to Rule 3A. Any party may address oral argument in a case and shall, before he concludes the oral argument, if any, submit if the court so permits concise statement and under distinct hearing written argument. Any party may address the oral argument. Then 3D kindly receive. This is very material, which has not been placed by them. The court shall fix such time limit for the oral arguments by either of the parties. It is absolutely within the prerogative of the court to whom he will direct to address oral arguments. Then kindly look to Indian evidence. Submission to your Lordship is
19 number.
Submission to your Lordship is kindly come to section 101. On the first day, your Lordship also pointed out this. Your Lordship got
118.
101. Burden of proof. Whosoever desires any court to give judgment as to any legal right or liability dependent on the evidence of fact which he asserts must prove that those facts exist. The election petitioner has come before your Lordship, asserted certain facts, praised before your Lordship that I have read evidence in support of my facts, alleged, believe my evidence, and give me the date. So the burden of proof lies on the election petitioner. Then your Lordship may kindly come to 102. On whom burden of proof lies? The burden of proof in a suit or proceeding, this is the election proceeding, lies on that person who would fail if no evidence at all were given on either side. Submission, your lordship, is if no evidence is laid on either side, then the election petition will fail. So the burden of proof lies on the election petition. Then 103. Burden of proof as to a particular fact. The burden of proof as to why any particular fact lies on that person who wishes the court to believe in its existence, unless it is provided by any law that the proof of that fact shall lie on any particular person. They have not shown any other procedure or provision of law to your lordship that they are not liable, burden does not lie upon them. Then, my lord, 106 is very important. Burden of proof proving the fact specially within knowledge. When the fact is specially within the knowledge of any person, the burden of proving that fact is upon him.
Yes.
I would then like to invite your lordship's kind attention to the verification and affidavit given by the election petition. They say that the facts pleaded in the election petition are within their knowledge. So burden of proof lies on them. My lord, so submission to your lordship is that since the burden of proof lies upon them, it is for them, in view of the provision, order item rule 3D, the court is to direct them that they should advance their argument. I am giving only two decisions. Both relates to elections.
Yes.
On the contrary, none of the cases cited before and accepted by my learned friend relates to elections. Now, your lordship, I will first cite latest decision, Supreme Court, 2010, 9 SCC, page 712. M. Chandra, appellant, versus M. Thangamuthu and Anand. Kindly turn to the next page. In this case, High Court fixed the burden of proof on the return page. Similarly, as is suggested by my friends before the person, I invite your lordship's kind attention to Classicum D at page 730. Head, burden of proof head, lay on election petitioner to prove that appellant return candidates still profess Christianity. Reasoning given by the court to reverse and shift burden of proof on appellant that in view of her admission that she was a Christian before converting to Hinduism, burden lay on her to prove that she had renounced to Christianity erroneous. Even assuming that High Court was justified in doing so, appellant by adducing present and reliable evidence that discharges ଯୋଉଠି ଆମେ ଟ୍ରାଏ କରିଛୁ relevant portion 770 classic mark. But rounds of challenging election. First declaration as scheduled cast in contesting from reserved constituency. Quorum and decree of proof held. Election petition on the ground of corrupt practice is not a criminal proceeding, but it is not less than a criminal proceeding with regard to proof. Though in present case, charges are not those of corrupt practices, they are not any lesser in terms of seriousness. Hence, burden of proof was on election petitioner to prove charges beyond reasonable doubt. On fact said, election petitioner did discharge that burden as evidence produced in support of his allegation did not inspire confidence and was mostly false. Then, J. Disposal of election petition, rules of procedure, hypertechnicality to be avoided. Here, readings and evidences are used to require to be read conjointly and not by applying hypertechnical approach of reading between lines to arrive at a finding against the requirement. Such an approach would defeat entire election process. Hypertechnicality requires to be eschewed and a ground reality kept in view while deciding election petition. However, such an approach need not be adopted when an election petition is filed on grounds of corruption. Inciting people on ground of religion, etc. Representation people election trial, burden of proof held lies on election petition. One cannot file an election petition based on frivolous grounds. The facts presented must be clear, concise, and unambiguous. An election result where the people elect their representatives cannot be taken lightly. For an election result to be annulled, there must be positive evidence to prove illegality of the election. The natural corollary is that the person who files an election petition must have a clear and definite case to prove that the election was illegal. Therefore, the burden of proof shall lie on the petitioner filing the election petition.
No, it's all right. It's not. So I just want to put a query to you, Mr. Misra. You are right that the election petitioner has got the burden of proof to prove that on this ground which has been taken, right? Can they not discharge the same if they reply to your case?
So I put it in just reverse. They have read evidence.
Yes.
They have read their pleading, they have read their evidence. Now they have to justify before your lordship that whatever they have pleaded in the election petition are true, because the burden of proof lies on them. Once they become successful, then your lordship may ask me to reply. Suppose they fail, does not inspire confidence before your lordship to their submission. It may be so, I may not be called upon to reply.
No, then what is this meaning of which he was harping on that the other party shall then state his case and produce his evidence, if any? Then these words which are occurring in this civil procedure code, sub-rule 2 of order 2, that and may then address the court generally on the whole case. How far we have proceeded or how we are will to be satisfied that this particular part has been, if I ask the election petitioner to begin the argument, then how this portion will be satisfied? Because it is your duty after producing the evidence. Yeah. Yeah.
They have relied upon sub-rule 1.
No, sub-rule 2. They are relying on sub-rule 2. Yes.
Then they are relying upon sub-rule 2 and submits to your lordship that I should address first.
Because this section says that after producing your evidence, the other party, you are the other party, you then address the court generally on the whole case. Then the another important feature is in number 3. The reply, the party beginning means he may then reply. So reply has to come from them. You are to state the case. They are to give the reply generally on the whole. Yes.
Kindly look to 1.
Yes.
1 is served. Fix is served. In 2, may not serve. I may state my case. I may not address on your lordship on my. The shall 3D.
Yes.
Sub-rule 2.1 on the day fixed for the hearing of the suit or on any other date to which the hearing is adjourned, the party having the right to begin, that is the election petitioner, shall state his case and shall state his case. এইটা এ পর্যন্ত হয়নি।
কোড হয়নি।
State his case.
The opposite party shall then state his case and produce his evidence. That means that stage is over. Oh, one time.
Day fixed for the hearing of the suit. The party is adjourned. The party having the right to begin shall state his case.
Okay, they have not stated his case, but they have directly produced the evidence. So that stage is over. That yes. They right.
Then 2.
Yes.
Then shall then state his case and produce evidence if any, may then address.
So there is a no, the difference between state and address, that is there in that one decision that they pointed out that state is a general thing, but address is some kind of argument. After you lead the evidence, after you produce the evidence, you are to address the court that on this ground, this election petition should be dismissed. Then the party.
The language is I may, not shall. 3D. This has to be read along with the 3D. କୋର୍ଟଙ୍କର ପାୱାର ରହିଲା ଏନି ପାର୍ଟି ମେ ଯୋଉଟା ରହିଲା ଏନି ପାର୍ଟି ମେ 3A ରେ ଏନି ପାର୍ଟି ମେ ଆଡ୍ରେସ୍ ଓରାଲ ଆର୍ଗୁମେଣ୍ଟ. This is specifically with respect to oral argument.
You are seeing these World Cup matches now. You find that whosoever is batting first, most of the time he wins. So why don't you begin?
I want to give that privilege.
Yesterday it also happened.
Again, say the undertaking the way they relinquish. Yeah, I'm ready to start.
Yes.
Otherwise, I'll spin a coin, provided it is not a soulless coin, right? Yeah.
The party beginning must have the last word.
Yeah. Yes.
Petitioner must begin. Petitioner must address the court last.
Right. That is against this. Right. If they relinquish the right, if any, to begin, then I will start. And I don't want a procedural irregularity.
I am happy on the.
Give up an undertaking that we will not
Yes.
raise this point as an issue. Then in appeal, my lords, whatever, my lords, either we may appeal or you.
When the issues have been framed,
Yes.
uh, both of you have given that these are the issues, and on a combined reading of the application or issues, I have formulated those issues. Now the duty of the we have already crossed those two stages. That means 2-1 we have crossed, 2-2 part we have crossed, right? Now the question is, what does it mean by may then address the court? Is it the discretionary power of the court, or may can in some cases be used as must when it requires a
Have been must, then one may could not have been there in this case.
no, it is question of interpretation. That if, in which situation the court may ask the respondent to begin the case, or in which case he say that no, the plaintiff should begin. So
Your Lordship has absolute civil procedure code authorizes the court
yeah.
and gives that power. And ordinarily the court will definitely ask that party to begin argument on whom the burden of proof lies. That cannot be shifted. Burden of proof cannot be shifted.
Burden of proof is different from oral arguments. Addressing the court.
Yes, sister.
Burden of proof, certainly it is my duty, my lords. The test is if both.
That is why I asked Mr. Mishra also that during reply also you can discharge that burden.
Yes. Burden of proof leads to the factum, my lords, that if both parties do not lead evidence whether the suit will succeed or whether it will fail. If it fails, then the burden of proof is on me to prove my point, to lead evidence to that effect.
You see, in the CRPC, there is a specific provision that who is to begin. Let us say trial before a court of session. There is a separate section for argument, and 234 is that section, and it says that when the examination of witnesses, if any, for the defense is complete, the prosecutor shall sum up his case, and the accused and his pleader shall be entitled to reply. So there is no ambiguity there. Here, because of that particular thing, which is discretion has been.
That part has been left to the court. Look to the pleading, look to the evidence, look to the burden of proof on whom lies, and direct that party to address the oral argument. Upon that decided.
No, it's all right.
There are two judgments, my lords, I've given your lordship, and if they relinquish this right, my lords, I'm also ready to begin, my lords. I have no problems.
Relinquishing means he says that just you argue and then we'll reply. And
your lordships will note down his statement at least that yes, they should.
No.
Yes. What more can you say? I am giving addressing my lord.
No, that's what I'm saying. Let it be noted then. Let an undertaking to that effect be given that yes.
No.
Irregularity.
No irregularity, probably. Your lordships, I brought it to your lordships' notice.
You cannot threaten the court.
No, I'm not threatening the court. I'm the last person to threaten the court. You are threatening me rather. I'm the last person to threaten the court. I'm just saying.
The provision of law, burden of proof, power lies with the court, that on whom the burden of proof lies, the court will direct him to address her.
Okay, suppose another thing, Mr. Mishra, whether you could say or not, suppose this is the pleading in the election petition and it is our written statement, and they have adduced their evidence in this way, but in view of the oral evidence which we have adduced through the respondent and other witnesses, as well as the documentary proof, their case should not be accepted and their election petition should be dismissed. That you cannot say at the beginning.
You can say it in a reply to their assertion and argument laid before your lordship. ଟିକେ ମୁଁ ଯୋଉ ଜଜମେଣ୍ଟଟା ରିଲାଏ କରିଛି
କୋଉଟା କହିଲେ?
ସେ ଯୋଉ ହଙ୍ଗାମତି 2010
ହଁ ହଁ
page 745 ଟିକେ ଆସ। It is a settled legal position that in election petition must clearly and unambiguously set out
745. Yes, 1 minute. 745. कौन दो yes?
79.
हाँ
So highlight portion.
हाँ ठीक है
Say that. It is a settled legal position that an election petition must clearly and unambiguously set out all the material facts which the petitioner is to rely upon during the trial. And it must reveal a clear and complete picture of the circumstances and should disclose a definite cause of action. In absence of the above, an election petition can be summarily dismissed. To see whether material facts have been duly disclosed or whether a cause of action arises, we need to look at the averment and pleading taken by the party. 81. One cannot file an election petition based on frivolous grounds. The facts presented must be clear, concise, and unambiguous. All the above cases and provisions, though do not deal directly with the issues in the case, they go on to emphasize that an election result where the people elect their representative cannot be taken lightly. For an election result to be annulled, there must be positive evidence to prove illegality of election. The natural corollary is that person who files an election petition must have a clear and definite case to prove that election was illegal. Therefore, the burden of proof shall lie on the petitioner filing the election petition. An election petition challenging the election of a returned candidate on the ground of corrupt practice is not a criminal proceeding, but it is no less than a criminal proceeding with regard to the proof required to be furnished to the court by the petitioner. Though in the present case the charges are not of those corrupt practices, they are not any lesser in terms of seriousness. Hence, the burden of proof is on the election petitioner to prove the charge he has made beyond reasonable doubt. The testimonies of the witnesses of the election petitioner do not qualify the test laid down in the Evidence Act to make the evidence admissible. It does not inspire any confidence. The evidence is clearly hearsay. As stated above, the opinion of the High Court is heavily relied on the fact that the burden of proof had been discharged and shifted to the appellant to prove that she had indeed renounced Christianity. Return of candidate को burden of proof का High Court shift कर दी. We do not approve of reasoning of the High Court to adopt this line of thinking. Burden of proof rests squarely on the election petitioner to show that the appellant indeed practiced and professed Christianity. In any event, the evidence put forward by appellant is consistent and reliable, as it has relied on the testimony of people who have actually visited the house of the appellant or attended her. High Court election set aside करथिले, Supreme Court ताको reverse. My submission to your lordship is that until and unless they satisfy with your lordship that they have been able to prove their pleading and evidence is worth accepting, they are not entitled to the meeting. Unless they are not entitled to any relief, how can I be called upon to reply to their allegation? So let them first justify and satisfy your lordship's judicial conscience that their pleading is correct.
Okay, that's all.
Yes, Malas. Malas, we have given two judgments.
Okay.
Lordship should consider it. And what my learned senior is also referring to, it is only regarding the time period a lordships may fix for oral arguments. That is order rule 3. Order 18, rule 3.
Okay,
Yeah.
heard Mr. Milan Kanungul and senior advocate and Mr. Gopal Agrawal for the election petitioner, and Mr. Vidyadhar Misra and senior advocate, and Mr. Tornikant Biswal, advocate for the respondent. Today, the date was fixed for argument. The Learned Counsel for the election petitioner cited some decisions and advanced his argument, referring to Order 18, Rule 1 and 2 of Code of Civil Procedure, that the respondent counsel, the counsel for the respondent, should begin the argument and address the court generally on the whole case in view of sub-rule 2 of Rule 2 of Order 18 of the CPC. And he relied upon decisions of this court in case of Swan Swetintaga decision, so also of the Honorable Supreme Court in case of Swanson.
Order
Mr.
2 and rule 3.
2 and 3, Mr. Vidyadhar Misral and senior advocate, on the other hand, refer to the section 87 of the Representation of People Act 1951. So also the provisions of the Evidence Act, that is section 101, 102, 103, and 106, which deals with burden of proof, and placed reliance on the two decision of the Honorable Supreme Court. And so also Order 18, Rule 2, 3A and 3D of the CPC, and placed reliance on the two decision of the Honorable Supreme Court in case of Tekchan versus Dileram, reported in 2001-3 Supreme Court cases 290, and M. Chandra versus M. Thanga Muthu and another, reported in 2010-9 Supreme Court cases 712. Order is reserved. Yes. But ultimately, you get ready because it
Yes,
will be
we are
delivered
ready, my lords.
within this period. Not only oral argument, but also, as I have stated about,
Note of argument.
prepare it because later on.
Lordships may also note that Mr. Mishra stresses that we should begin first. May note that also, because he says that we should begin.
And relying on so and so, say that in the factual scenario, to substantiate the case of the election petitioner, the Learned Counsel for the election petitioner should begin his the case.
Yes.
Should begin his argument first.
Yes.
All right.
Yes. Deeply.
Weekly list item number 1.
Item 1 can kindly pass over.
What is this matter? It is 49. RI for 7 years, fine 5,000 in default ones. Okay. So admit. Huh? Huh. So admit call for the trial court record, deposition copies to be supplied to the Learning State Council, interim application for bail and stay realization of fine to be considered after receipt of the trial court. Display board रे देखिଛନ୍ତି ଚାଲୁଛି ବୋଲି item number 3 ठीक ଅଛି.
Item 4. May I please, my lord. Convicted under section 20B 22C of NDPS Act for a period of 10 years only. Page 54.
54. Years, right. Admit call for the trial court record, interim applications for bail and stay realization of fine to be considered after receipt of the trial court. Deposition copy to be supplied to the Learning Council for the state. Yes.
Item 5.
May I please ask? The 2 years conviction in PC Act, my lord. And the appeal persons are husband and wife.
Page relevant page is
90. Running page 90, internal page
90.
81. My lord.
89. Prafulla Chandra Panikar. Right. is sentenced to undergo RI for 2 years, fine 10,000 in default, RI for 3 months under section so and so, and Renuwala Panigrahi is sentenced to so and so. So it's a appeal filed by both the appellants.
My lord.
Both the accused, okay. And all right, you are on bail, both of you.
My lord.
Yes, Mr. Das.
I have already filed my appearance form on 3/11.
Mr. Sanjay Kumar Das, Running Standing Counsel, appearing for the Vigilance Department, submitted that he has already filed the appearance memo on 3/11/2023. Let the registry place the appearance memo on record. Henceforth, the name of Mr. Das be reflected in the cause list as well as the top of the brief. Hart admit he was on bail, bail allowed, stay realization of fine. Free copy of the order be handed over to the London Standing Counsel for the Vigilance Department.
Obliged.
Item 6.
I'm on behalf of Mr. G.K. Naik, they're convicted under section 304 part 2, sentenced to undergo RA for 10 years and fine of rupees 20,000.
What is the operative part of the judgment?
Lordship, kindly come to page 50, my lord.
50. RI for 10 years, fine of rupees 20,000 in default to suffer swans. Okay. All right. Hard admit, call for the trial court record, deposition copy to be supplied, interim applications for bail and stay realization of fine to be considered after receipt of the trial court record. Yes.
Item 3, my lord.
3 I have already admitted, Mr. Roy.
Only your lordship say kindly list this matter along with CRLA 1132 of 23. 1132 of 23.
That has already been admitted.
Yes, my lord.
All right, list this matter, non-appeals karivani, admit kolapore, list this matter along with CRLA number 1132 of 2023. And it is stated by Mr. Roy that trial court record has already been called for in the said appeal. The registry shall verify whether the trial court record has been received in the said appeal or not. Yes.
Obliged.
Item 7.
Mr. Lakshmi Narayan Patel. What is this, Mr. 23. Mahendra Dilla, sentenced to undergo RI for 4 years and to pay fine of rupees 10,000. 20B2B. Yes. Yes, Mr.
He was on bail, my lord. During trial, he was on bail, man.
And after conviction, you have been taken into custody.
Yes, my lord.
All right, hard admit, call for the trial court record. Considering the submission made by the London Counsel for the petitioner, that the petitioner was on bail during trial and he has never misutilized his liberty while on bail. And bar under section 37 is not applicable for an offense under section 20B2B of the NDPS Act, and there is no chance of early hearing of the appeal in the near future. After hearing the London Counsel for the state, bail application is allowed stay realization of fine.
Item number 8.
Mr. Jyotirmoy Sahu. What is this, Mr.
Item number 10.
10 against conviction under section 324 IPC, RI for 1 year and fine up to 1,000.
Relevant page is
Page 27, internal page
27.
Internal
Okay.
page 20.
Convicts are sentenced to RI for 1 year to pay fine of rupees 1,000. In defaults one, so 324. Okay, you are on bail during that. So admit he was on bail, bail allowed, stay realization of fine. Yes.
Item 11.
May please your lordship. The relevant page is page 45, 48, my lord, and the appellant is here is convicted for 3 years for the commission of offence under section 409 of IPC.
Single appellant.
Single appellant.
Bhubana Mohan Das is sentenced to undergo RI for 3 years, pay fine of rupees 1, so in default to undergo to 409. Then RI for 4 years, fine is 10,000. In default to undergo 1, so 13.2. Okay, concurrently. So it is 4 years now. You have received the copy.
I have filed my appearance on 4/11.
All right, Mr. Sanjay Kumar Das, London Standing Counsel for the Vigilance Department submits that he has filed his appearance memo on 4/11/2023. Let the registry place the appearance memo on record. Henceforth, the name of Mr. Das be reflected in the cause list as well as the top of the brief. Hard admit he was on bail, so bail allowed. Acha, after conviction, he has been taken into judicial
No, my lord.
custody.
Sorry, my lord. I was on custody since 17/10/2023 by virtue of the warrant issued by the London Trial Court, my lord, for my non-appearance in the date fixed on 11/10/2023 for argument.
No,
Thereafter,
at the time of pronouncement of the judgment, you are in custody.
yes, my lord.
Okay. All right. Though the petitioner was on bail, but during trial, but subsequently, he was taken into custody, and after pronouncement of the judgment, also he is now in judicial custody. Bail allowed, stay realization of fine.
Obliged. Free copy of the order.
Yes, free copy.
Obliged.
Item 12.
May I please, your lordship? Yes.
Item 15, my lord, pass.
Pass. Item 15 also next week, madam. You have not received the
Yes, madam.
notice sufficient is na?
Notice sufficient.
All right. The Land and Council appear kurjani pra Mr. Mahesh Das.
Notice.
Okay, it's all right. The you are seeking for adjournment on the ground to get the case diary. Okay. The Land and Council for the state submits that the matter may be taken off next week in order to make the CD available along with the instruction regarding criminal antecedent, if any, against the appellant. Put up this matter on we commencing from 13th November 2023.
Item 16.
16, my lord. Your lordship had order dated 17/10/2023, directed for the production of the eyewitness Gaurav Agarty before the Law and Trial Court. The date was fixed on 30th of October. Whether he has been examined or not, I will take instruction.
Who order him actually?
17/10/2023, my lord.
The Land and Council for the appellant seeks for an adjournment to ascertain whether the eyewitness Gaurav Agarty has been examined on 30/10/2023.
Has not been examined.
Not examined.
Not because the PO is on leave.
30 purely on leave.
So now
He will on leave for a long time.
When the next date is fixed?
I take out tomorrow. I will. In the meantime, I will get all the instructions.
ସେଇ ଡେଟରେ ତାକୁ ପୁଣି କହିଦେଲେ ସେ ଇଏ କରେଇଦବ।
ଲିଭରେ ଅଛନ୍ତି ମାସେ ପାଇଁ।
ମାସେ ଖଣ୍ଡେ on leave ଅଛନ୍ତି।
କୋଉ କୋର୍ଟ?
ଡିଜେ ପାଟନାଗର ଆଡିସନାଲ ସେସନ।
ଡେଟ୍ ପକେଇଥିବ ନା ଗୋଟେ ସେଦିନ ପରେ ସେ ଯୋଉ ଚାର୍ଜ ରେ ଥିବେ ସେ ଗୋଟେ ସେ ଅନୁଯାୟୀ ବୁଝିକିନି ଗୋଟେ ଡେଟ୍ ପକାନ୍ତି ତ ସେ କେବେ ଡେଟ୍ ହେଲା ବୁଝିଯିବେ। ହଁ ଏଇଟା କାଲିକି ଡାକିବେ ଏଇଟା ରଖିଥାନ୍ତୁ କାଲି ଟୁମୋରୋ। That means 7/11.
Item 17.
17 permitted to
Mr. Padhi, Manoranjan Padhi. अच्छा दीटा फाइल कर दीजिए टुकुना मिश्र भी ना दी। Okay, 7/11/2023. Next.
Item 19.
We are appearing for, yes, Mr. Mahapatra, you are appearing. And you have received the case diary? Yes.
The petitioner is inside custody since 8/11/2022.
Is it the first application or earlier rejected?
First application.
First application. CRLA 695/2023. What is the date of custody?
8/11/2022, Your Lordship.
Charge sheet under section
364, 302, 201,
just go slowly. 364, 302,
201,
yes.
120B of IPC and section 32B VA of SC and ST Act. This is the order of the co-authority of Lordship. Because the written order was passed by your Lordship.
Dambordhar alias Kanhu Raut. Deceased Hiteshwari Naik was found missing from her house since 3/11/2022, for which a report was lodged by her father, Dhaniram Naik, on 9/1/2022 before the inspector in charge of Nuapada police station. Though the case was registered, investigation commenced, but the whereabouts of the deceased could not be traced out, and ultimately a skeleton was recovered from a field in the month of November 2022, and it was identified to be that of deceased Hiteshwari Naik. Postmortem was conducted on the skeleton, and it was found to be a case of manual strangulation. Land Council submitted that there is no direct evidence against the appellant, and the only material is the confessional statement of co-accused Premananda alias Sonu Sahu. That means this petitioner before police. And it is the prosecution case that the said co-accused was having love affair with the deceased, and he made her pregnant, and then the deceased was killed. Land counsel for this confessional statement was made before whom? Police.
Before police, Your Lordship.
Though in the confessional statement of the co-accused, it appears that there was criminal conspiracy between the said co-accused and the appellant and others, but there is no clinching materials to that effect, and in view of the available also. Learning counsel for the state that is a case of circumstantial evidence, place the 164 CRPC statement of the so and so. So the only material against you is that confessional statement before police, or any other matter?
And order 27 of evidence act.
What was recovered?
Skeleton was recovered, Your Lordship. To cause of death, Your Lordship, manual strangulation lekha ichi. Sethere cause of death re lekhichande, there is no definite finding to suggest the cause of death due to skeletonization. However, considering the position of nylon rope and the pattern of disposition, homicidal strangulation could be most probably the cause of death.
Sure. Skeleton court thila.
It was buried in a deep. ତାକୁ ମାଟିରେ ପୋତି ଦିଆଯାଇଥିଲା. Now, on his
How it
instance,
came to your knowledge? If it would have been in an open place, matter is something different. You knew that inside the sand or soil, it was dogged out and then recovered, and it is within your spatial knowledge. So this is very relevant under section 27. Whether it would be sufficient to convict you or not, that's a different matter. That is to be seen at the stage of trial. But when a girl was made pregnant, he was killed. It's by way of strangulation, and he is a member of scheduled caste or scheduled tribe. And why bail is to be granted unless?
May I pray, Your Lordship, in this matter can be taken up for Your Lordship? Some other evidences are there. I will go through it. Both of the evidence are here.
7/11/2023. Yes.
Item 20.
It is no. ये कागज का भी रखी था बुझलो. Keep this paper. Tomorrow you have to hand over. Yes, item number 20. 20, Mr. Dhirendra Nath Behera. You are arguing this, madam. Item 20, your matter. Okay.
This is offense under section 147, 148.
Just a minute. Mr. Tripathi.
Yes, Miller.
You are to argue. Notice sufficient.
Notice sufficient on 14/10/23.
14/10/23. Item 20, my lord. I am here, mother. But Mr. Tripathi says that it is wrong. It is 21.
That is 21, Miller.
No, it's I am in item
21.
number 20.
That's
So
for the first time, I think, Miller.
it is coming for the first time.
I think because in today we have not received the copy of the SHRI. We have
No. Just
otherwise the direction was there to serve a copy, but there notice call for
wait.
there.
It's a case of
Copy of-
conviction. Shyam Meher.
Fiction copy nine.
J.S.Sri Behera Learning Council for the appellant appearing through virtual High Court Sambalpur submitted that she has removed defect number so and so. Okay. One of the offenses under section 3 SC let extra copy of the appeal memo. Okay. No, this the order has already been passed, Mr. Das, on 9/10/23, asking the Learned Council to supply you the extra copy of the appeal memo. So, what is your instruction? She has not supplied. Madam, have you supplied the extra copy?
No, sorry, ma'am.
Outside the copy of order was uploaded on the official website on 12th of October, sir. And I have uploaded the same, the CRLA petition.
Okay, then have you?
Due to sir,
it is already
some
served on the informant. Okay. Okay, then you can argue. Is it the first application or earlier rejected?
earlier rejected by CRLA 1188 of 2022 due to the previous council not raised the bail application on behalf of the present petitioner, present applicant.
Just a minute. 11.
CRLA 1188 1188 of 2022. I have filed a copy of CRLA at Annexure 2.
Just a minute. Annexure 2 at page?
At page 102 up to 108.
Okay, it was not pressed.
Yes, sir.
Not pressed in CRLA 1188/2022. What is the date of custody?
Date of custody is since 19th May 2021.
What are the offenses under which charge sheet submitted?
302, 147, 148, 294,
Go slowly, madam. 147, 148, then?
294,
Yes.
302,
Yes.
149 IPC.
Yes.
read with section 31 RS
Hmm.
P2 VA of SC and ST Prevention of Atrocities Act.
Okay. What is the name of the deceased?
Birendra Kumar.
Virendra
Kumar.
Kumar.
Sir, Birendra Kumar.
Date of occurrence is
18th May 2021.
Is there any eyewitness to the occurrence?
Yes, sir. The main eyewitness of the occurrence, her wife, Nilabati Kumar.
Wife of the deceased.
Wife of Nilabati Kumar.
Wife of the deceased, no?
Yes, sir.
Okay. Nilabati
Nilabati
Kumar.
Kumar.
Okay, Mr. You please place that Nilabati statement and what role he has attributed against this petition.
ମୋର ନାମ ନୀଳବତୀ କୁଅଁର ଭିଲେଜ ସୋଏନ୍ସୋ ବୟାନ ଦେଉଛି କି ମୋର ସ୍ୱାମୀ ଆମ ଗାଁରେ ଝାଙ୍କର କାମ କରୁଥିଲେ। ମୋ ଘର ପାଖରେ ମୋର ଭାଇ ଗୋପୀନାଥ ଅଟ୍ଟିଙ୍କୁ ଖଣ୍ଡିଏ ଜାଗା ଦେଇଛି। ସେ ଉକ୍ତ ଜାଗାରେ ଘର କରି ରହୁଛି। ଉକ୍ତ ଜାଗାକୁ ଆମ ଗାଁର ମେହେର ପରିବାର ଲୋକମାନେ ତାଙ୍କର ଜାଗା ବୋଲି କହି ଦାବି କରି ବାରମ୍ବାର ଝଗଡ଼ା କରୁଛନ୍ତି। ଆଜି ତାରିଖ 18/5/2021 ଦିନ ଗୋଟାଏ ସମୟରେ ମୁଁ ଓ ମୋର ସ୍ୱାମୀ ଆମ ଘର ସାମ୍ନାରେ ଛିଡ଼ା ହୋଇଥିଲୁ। ଏତିକି ବେଳେ ଆମ ଗ୍ରାମର ଦ୍ରୁପଦ ମେହେର, ଅମୃତ ମେହେର, ଆକୁଳ ମେହେର, କୈଳାସ ମେହେର, ଭବାନୀ ମେହେର, ମନୋଜ ମେହେର, ମନଭାଙ୍ଗି ମେହେର, ଘନଶ୍ୟାମ ମେହେର,
Ghanshyam is the petitioner.
ଗଣେଶ ମେହେର,
Leave the other names. You just.
so and so ମୋର ଭାଇ ଗୋପୀନାଥ ଅଟି ଘରକୁ ଯାଇ ସେ ଘରେ କରୁଥିବା ଜମିର ପଟ୍ଟା ଦେଖିବାକୁ କହି ଝଗଡ଼ା କଲେ। ଏହା ଦେଖି ମୁଁ ଓ ମୋର ସ୍ୱାମୀ ସେମାନଙ୍କ ପାଖକୁ ଯାଇ ଝଗଡ଼ା ନ କରିବାକୁ ବୁଝାଇଲୁ। ଏଥିରେ ମେହେର ପରିବାର ଲୋକମାନେ ଆମକୁ ରାଗି ଯାଇ ରହ ଦେଖିନେବୁ କହି ସେଠାରୁ ଚାଲିଗଲେ। ଏହାପରେ ମୋର ସ୍ୱାମୀ ଓ ମୋର ଭାଇ ଘଟଣା ସମାଧାନ କରିବାକୁ ମେହେର ମାନଙ୍କ ପାଖକୁ ଯାଇଥିଲୁ। ସେ ସମୟରେ ସେମାନଙ୍କୁ ଦେଖି ଦୁପୁଦ ମେହେର, ଅମୃତ ମେହେର, ସୋ ଆଣ୍ଡ ସୋ and the present petitioner ତାଙ୍କ ପରିବାରର ଆଉ କିଛି ଲୋକ ଇଟା ପଥର ଠେଙ୍ଗା ଧରି ଆସି ଖରାପ ଭାଷାରେ ଗାଳି ଗୁଲଜ କରି ମୋର ଭାଇ ଗୋପୀନାଥ ଆଟିକୁ ଆକ୍ରମଣ କଲେ। ଏହା ଦେଖି ମୋର ସ୍ୱାମୀ ସେମାନଙ୍କୁ ଛଡ଼େଇବାରୁ ଏଇ ଲୋକଟା ବେଶୀ ଟାଉଟରି କରୁଛି କହି ୟାକୁ ଆଗ ମାର ବୋଲି କହି ମୋର ସ୍ୱାମୀକୁ ସମସ୍ତେ ଇଟା ପଥର ଠେଙ୍ଗା ଇତ୍ୟାଦିରେ ମାରିବାରୁ ସେ ଗୁରୁତର ଆହତ ହୋଇ ତଳେ ପଡ଼ିଗଲେ। ଏହା ଦେଖି ସେମାନେ ସମସ୍ତେ ଘଟଣାସ୍ଥଳରୁ ପଳାଇଗଲେ। ମୁଁ ମୋର ଭାଇ ଏହା ଦେଖି ପାଟି କରି ଡାକିବାରୁ ଗାଁ ଲୋକମାନେ ଆସି ରୁଣ୍ଡ ହେଲେ। ଏହାପରେ ମୋର ସ୍ୱାମୀକୁ ଟେକି ନେଇ ଘରକୁ ଆଣିଲୁ। ତାଙ୍କ ମୁଣ୍ଡରେ ଗଭୀର ଆଘାତ ହୋଇଥିବାରୁ, ରକ୍ତ ବାହାରୁଥିବାରୁ ଏବଂ ଦେହ ସାରା ଆଘାତ ହୋଇଥିବାରୁ ଆମେ ଆମ୍ବୁଲାନ୍ସ ଡକାଇ ବୁର୍ଲା ଡାକ୍ତରଖାନାକୁ ନେଇଗଲୁ, କିନ୍ତୁ ସେଠାରେ ଡାକ୍ତର ତାଙ୍କୁ ମୃତ ଘୋଷଣା କଲେ। ଏହାପରେ ମୁଁ ମୋର ପୁଅ ସଞ୍ଜୟ କୁମାର ସୋ ଆସି ରିପୋର୍ଟ ଦେଲୁ।
What is the PM report? Oh, so number of injuries are there. So anybody has been released on bail, madam?
Sir, all are released on bail except two accused persons who are the ex-convicts, Ahalya Meher and Ganesh Meher. All other co-accused persons are released on bail. On the same set of evidence, co-accused persons, namely Drupad Meher, Akula Meher, Amruta Meher, Kailas Meher, Bhavani alias Bhuvani Meher.
So what is the difference between those co-accused persons and this man? You know, as you placed, it's a similar in nature, omnibus nature of hard. Miss SHRI Behera, Learning Counsel for the appellant, appearing through virtual High Court, Sambalpur. She the Learned Counsel for the state submitted that the notice on the informant is sufficient. Stop. None appears for the informant. Ms. Behra submitted that earlier the petitioner approached this court for bail along with co-accused persons in CRLA number 1188 of 2022, which was not pressed. So far as the petitioner is concerned, so far the appellant is concerned. The appellant is in judicial custody since 19/5/2021, and he has been charge-sheeted under sections 116 Khaijadere. The occurrence in question took place on 18/5/2021. And the widow of the deceased Birendra Kumar, namely Nilavati Kumar, is an eyewitness to the occurrence, and she has stated in an omnibus manner that on account of civil dispute, the accused persons assaulted the deceased by means of brickbats, stones, and lathi, and co-accused persons similarly situated have already been released on bail by this court in DLAPL number 1188 of 2022. And therefore, on the ground of parity and equity, the bail application of the appellant may be favorably considered. Stop. Learned Counsel for the state has produced the case diary and placed the statement of Nilavati Kumar and fairly submitted that the petitioner, that the appellant is similarly situated like the co-accused persons who have been released on bail. Considering the submission made by the Learned Counsel for the respective parties, nature of accusation against the petitioner, release of the co-accused persons on bail, period of detention of the petitioner in judicial custody, I am inclined to release the appellant on bail. It shall attend the trial court on each date and shall not try to tamper with the evidence and shall not indulge in any criminal activities. Violation of any terms and conditions shall entail cancellation of bail allowed. Yes.
Item number 21.
My plea, Your Lordship. This regular bill, Your Lordship. The appellant
is it the first application or early?
First application.
First application.
Yes, Lordship.
Notice sufficient, Mr. Tripathi?
Yes. Yes. 14/10/23.
What is the date of custody?
My Lord, 19/6/2023.
Charge sheet submitted?
Yes, Your Lordship.
What are the offenses?
147,
Yes.
148, 323.
Go slowly.
My
Yes.
Lord.
323 pare?
307.
Yes.
354. 506. 302. 341. 294. 149 of the IPC, and under section 31 RS 32V VA SC and ST PA, Your Lordship.
What is the name of the deceased?
Name of this is Kailash Meher.
Kailash
Meher.
Somebody is injured.
Two injured eyewitnesses are there. Your
What is the
Lordship.
name? Suppose
Gajanan Meher, Niranjan Meher.
Yes, place one of them statement
My
and
Lord.
how they have implicated this petty appellant Sushil Bariha.
My lord. ମୋର ନାମ ନିରଞ୍ଜନ
statement place କରୁଛନ୍ତି
ନିରଞ୍ଜନ ମେହେର।
Okay.
ମୋର ନାମ ନିରଞ୍ଜନ ମେହେର, ବୟସ 30 ବର୍ଷ, ପିତା ସ୍ୱର୍ଗତ ଲିଙ୍ଗରାଜ ମେହେର, ନିବାସୀ ଚକରକେନ ଥାନା ସଦର, ଜିଲ୍ଲା ବରଗଡ଼। ଆଜି 4/8/2022 ତାରିଖରେ ଦେବା ମୋର ବୟାନ ହେଇକି ଯେ ମୁଁ ଜାତିରେ ଚମାର ଅଟେ। ଗତକାଲି 3/8/2022 ତାରିଖ ମୁଁ ଚକରକେନ ଭାଟି ପାଖରେ ଥିବା ଗୋଟିଏ ସନ୍ଥ କବି ଭୀମ ବହି ମହିମା କଲେଜର ନୂତନ ଗୃହ ତିଆରି କାର୍ଯ୍ୟ ଚାଲୁଥିବା ବେଳେ ସେଠି ଆମ ଗାଁର ପପୁ ସାହୁ ଆଉ ତପସ୍ପର ସାହୁ, ସୁନୀଲ ପ୍ରଧାନ, जागेंद्र प्रधान, जितेंद्र बाग, अमर सेठ, मानस साहू, समीर भोये, विकास साहू, सुशील बरिया
पिटी अपलांट
माइल
यस कोन हला पछा अन्य ना गुडा छाड़ दियो कोन हला
तापरे आमे साही को जाई सेठारे कैलाश मेहर, गजानन मेहर, नारायण मेहर को सब कथा कहिबारु मो अन्य 3 जण जाको उक्त जाग
को कोन से मान करथिले
गाली गुलोज तीर मध्य
गाली गुलोज कले ओ जाति रे आक्षेप कले।
ओके
तापरे आमे साही को जाई सेठारे कैलाश मेहर, गजानन मेहर और नारायण मेहर को
कहलु रास्ता तापर कोन हला
कहिबारु मो अन्य 3 जण जाक उक्त जागा को आसी ताकू पचारिबारु समस्त मिसी आम सांगरे जुक्ति तर्क कले। समीर भई गोटे बाउंस कटन रे कैलाश मेहर मुंड को लक्ष्य कर जीवन रे मारिदेबा औषधे रखी मारिला। सुनील बरिया मध्य गोटे बाउंस कटन रे गजानन मेहर मुंड को लक्ष्य कर जीवन रे मारिदेबा उद्देश्य रखी मारिला, जहाँफल 2 जन को मुंड फाटी रक्त जुड़ुबुड़ू हेले। मानस साहू, जोगेंद्र प्रधान, जितेंद्र बाग मध्य कैलाश मेहर, गजानन मेहर, नारायण मेहर और नारायण मेहर मते बाड़ी रे पिटामरा करिसेंती, जहा द्वारा मोर अंटा बाम डाहण आंठुरे पिठिरे।
No, that means so far as the deceased is concerned,
Samir Bhoi, there is specific allegation against Samir Bhoi, your lordship. Therefore, your lordship granted bail to the other accused person.
But you have assaulted that
Gajanan
by means of a bamboo stick, lathi. Okay.
Yes, lord.
And that too on the head.
Yes, lord.
What injury he has sustained?
He sustained.
What is the injury Gajanan Meher has sustained?
2 injury sustainment, both are simple.
Are the Learned Counsel for the Appellant Learned Counsel for the state, the Learned Counsel for the state submitted notice on the informant is sufficient, non appears for the informant. Considering the submission made by the Learned Counsel for the appellant that the appellant is in judicial custody since 19/6/23 and he has been charge sheeted under section so and so, and as per the eyewitnesses account of 2 injured persons, namely Gajanan Meher and Niranjan Meher, the appellant Sushil Bariha has only assaulted the injured Gajanan Meher, who has sustained 2 simple injuries, which is not disputed by the Learned Counsel for the state. I am inclined to release the appellant on bail allowed.
Item number 22.
May I please illustrate? My lord, on the last occasion, my lord, on 17/10 of 2023, my lord, last occasion.
Notice sufficient, Mr. Tripathi?
Yes, my lord, 22/8/23.
The my last occasion, lordship directed to produce the certified copy of depositions 7, 8, 9, 8, 9, 10. I have already filed, my lord.
Last order means 17/10.
17/10/2023. 7 পর্যন্ত দিয়েছিল 8, 9, 10 টা মানে।
Have you given it to the Learned State Council?
These are not certified copy.
I have
ନାଇଁ certified copy ଗୁଡା
ନା ମତେ ଯୋଉଟା ଦେଇଛନ୍ତି certified copy ନୁହଁ, type copy only.
ତାର type copy ଗୁଡା type copy କାଇଁ କୋଉ ଦଉଥିଲେ ତାଙ୍କୁ?
ଆସିନାହାନ୍ତି କୋର୍ଟ ତ ସେଥିପାଇଁ।
ହଁ ସେ ଆସିନାହାନ୍ତି, ଆପଣ ତାଙ୍କୁ ହ୍ୟାଣ୍ଡ ଓଭର କରିଦିଅନ୍ତୁ, ସେ ପଠେଇଦେବେ। ଆପଣ ଏଟା କାଲି ନିଆଯିବ, ସିଏ ମିଷ୍ଟର ତ୍ରିପାଠୀଙ୍କୁ ହ୍ୟାଣ୍ଡ ଓଭର ହେଲା। ଏଟା ରଖିଥାଅ, କାଲିକି ଡାକିବ।
Item number 23.
7, 11, 20, 20.
last